across those beautiful fruited plains of the internet. Before we go ahead and get started, we are on day 2 of the Sussmann trial, and we've got a lot to get to. I just got the transcripts. They were coming in hot. They're still a little bit Sussman-y. We got to let those air out a little bit, but we are ready to go through them. We've got 3 different witnesses that came out in trial today. I want to start off by getting our bearing straight on the mind map. Now, the mind map got a lot of changes over the last 24 hours because I was going through it with a finer tooth comb. Let's see what we've got here. And thank you to Ronnie Cole here for that super chat. Says, I support the tardiness. Well, I appreciate that there, Ronnie Cole. I was skidding in here. You know, part of the problem is my scheduling tool. I use Restream. It either allows me to do 3:15 or 3:30, and I didn't want to wait till 3:30, and 3:15 was a little too soon, but we're skidding in here. But thank you for that, Ronnie Cole. Going to apply that towards these transcripts here. But let's take a look at what some of the mind map changes entail. You see, look at this thing. It's already, we're on day 2 of this trial, and it's already just becoming pretty unwieldy, but we can close a lot of this up. I want to show you what we created yesterday. Here, of course, was where we left off yesterday, can pick up today. We were talking about jury selection. This was day 1. Something very interesting happened on day 1 when we were picking juries. We got a video of, look at who this is. It's Durham.
Counsel John Durham's investigation.
Look at him. Who is that guy?
Russia probe starts today.
Where did he come from?
Russia hoax.
So we've got Sussmann and Durham who are out there. Now we get to see Durham for the first time, I think, ever. He's very, very off limits to the media. So we actually see a photograph of him going into court. That was yesterday. But yesterday, we were having questions about what the jury looked like. And I still have some questions about what the jury looked like. A lot of the people in the courtroom had questions about what the jury looks like. And I wanted to share this with you, just not because I want to dive into this a lot, but this was the PM transcript that we didn't get to yesterday because we were sort of waiting for the transcript to come in. For those keeping tabs on sort of when I get these, I got today's transcript about 30 minutes ago now, maybe, by the time I got everything sort of scheduled and posted that we were going to be going live, about 30 minutes. Last night, I got the PM transcripts very late. I got them about 11:30, I think, their time, which would have been about whatever that is, 8:30 here. Maybe about midnight their time. So we may get them late, but what I'm seeing is that the afternoons are a little bit lighter than the morning session. So you see here, they started back up at 1:38. They're typically done at about 4:30, 4:45. And so they were pretty much done with the trial in the first part of the morning. And we're going to see that pattern, I think, continue throughout the rest of this trial. But just for completeness, I wanted to show you what happened yesterday. All right, so yesterday, we were picking up with all of the jury selection, going through everybody. We fast forward. They're still picking jury all the way down here to the bottom. Then they take a break. They come back and they do roll call, right? Everybody comes back in. 517, you here? Yeah, I'm here. 764, how about you? Yeah, how about 337? Yeah, I'm here, right? And they go through all of them. But then we see, Your Honor, we have a panel of 38 people selected. All right, great. We got 38 people. That's a lot of people. And then there's this conversation about what the heck are we going to do with all of this? How are we going to whittle this down to our final people? And look at this. Mr. Al Gore, prosecutor, says, look, Judge, I'm sorry about this. I apologize. I'm just making sure we understand the guidance here. Okay, so we've got alternate seats. We can go over juror numbers for the 4 that we've just read off, just so we're clear. We're tracking these 2 jurors who were problems. And then the court says, hold on a minute. Courtroom deputy says, listen, Your Honor, I can do it. I can make it easier. So court says, all right, let Ms. Jenkins do it. Then prosecutor says, okay, yeah, Ms. Jenkins, what do you got for me? So then the courtroom deputy comes out and says, all right, counsel, look, the alternate jurors are here, here, and here. And Mr. Al Gore says, great, that's the prosecutor. But then the defense comes in and he's like, Berkowitz says, one other question, Judge, since I've got everybody here. We've got our fundraising jurors and our understanding and all these people. Then the courtroom deputy's like, 1 second, Your Honor. I'm sorry, counsel. Let's continue to hash through this. So my point is, just watch how long this continues to go. Mr. Berkowitz, you see, I think that's what I'm trying to evaluate. There's 12 jurors plus 16 strikes, gives us a total of 28, then 4 alternates is 32. But even if all 16 are used, the 4 alternates have already been identified, and so on and so forth. Then the courtroom deputy Jenkins comes back in. Your Honor, if I can explain it this way, I think it makes it a little bit simpler for the parties. And then the deputy goes and explains this whole thing. But then the judge is confused. He says, but Lauren, must be Lauren Jenkins there. Question is, you know, obviously he can strike people. My point is you might run the risk of cutting off the alternatives. And Berkowitz says, yeah, I understand that. And look, it just goes on and on and on. Okay, so even you're talking to some of the most practiced lawyers in the entire country. In DC, they've done this many, many times, and every single time jury selection, no matter where you go, is just kind of a convoluted mess. And the judge is going through, the defense has no idea what's going on, the prosecution has no idea what's going on, the court clerk tries to explain it multiple times. Finally, they get to it, and they come back, and the judge finally says, all right, ladies and gentlemen, this is what I call musical chairs. I'm going to have you stand up, and then other people are going to sit in your place. So literally, the judge is going to say, you stand up, you sit there, you stand up, you sit there, and you stand up, and you sit there. And it's going to go through this until we get everybody seated. So watch. 178, please stand. 0586, I'm going to ask you to take the seat. All right. 170, you stand. 290, take their seat. And around we go until finally we fast forward to the bottom and we see we've got a jury selected. Ladies and gentlemen, that's your service. If you have not been seated, you are gone. And that's our jury. Now, the problem with this is that I actually went through all of this. I went through and tracked all the different seats here. 760, take the seat. So what I did last night, because I don't know, I can't help myself on some of this. But last night I went through this and I said, okay, 505, please take your seat. Well, who the heck is 505? Because we had 200 pages, 300 pages of transcripts from yesterday. And I went through and I assembled all of them. And by the way, this mind map is available if you would like to follow along. It's in the description below, but I will also throw it here in the chat right now and make sure that puppy gets pinned up there. So if you'd like to follow along in the mind map, please go ahead and do that. But the summation of this, right, to summarize day one yesterday, I wanted to just share with you briefly who the jurors are. Okay, we've got at least 10 of them identified that I was able to correlate with the seat musical chair selection with data from voir dire. But here we can see we've got 1131. She's a teacher. She's a gymnast. This was an individual who said that this whole thing was basically boring. She said, Your Honor, I really think that this is kind of a boring trial, or that was my first impression. So not much there. We have 586 is a Treasury Department person. This is also somebody who donated to the Democrats in 2016. We talked about him yesterday. And if we, oh my goodness. Okay, so can we just open this up? It's going to download it, but well, I'll show you. You can see there, this doesn't zoom in very well here, but it says this is on the Democratic side. If I would have donated, it would have been on the Democratic side. And that's pretty much par for the course in DC. 290, we have a medical illustrator. We have the Elden Ring guy. Remember we talked about the Elden Ring? And he was 25, not really interested in much about this at all. Judge said, what's your favorite game? He said, well, it's probably, Elden Ring. And judge said, what the heck did you say? What? One more time. I'm sorry. What? And he says, Elden Ring, judge. Super hot right now. And the court says, all right, well, maybe the lawyers will know more about that. I have no idea what you're talking about, son. And so he's going to be on the bench. We talked about the lawyer who also worked at Big Law. She is 0731. She also was a Hillary donor. We talked about her yesterday. And this one was very interesting. This was the woman who was saying that I believe, that I could be impartial. But you can see the rest of these people are not, one way or the other, particularly biased. I think based on what we know, we have the Elden Ring guy, we have the mechanic, we have a father who actually worked for a senator. This guy was a Republican senator. And I believe his name, he was on the Senate Foreign Relations Committee. The father was working for Senator Corker, who was on the Senate Foreign Relations Committee. We have somebody from the Peace Corps on there, so you know what political leanings they have. We also have a government contractor. So the three biggest people that are the most challenging for the Durham prosecution, most beneficial for the Sussmann defense, are going to be this person, 517, and I forgot to mention her, but this person works at the Smithsonian. She has a strong dislike for Trump. So if you're following along on the mind map at home, check this one out, because if you click these images, you'll see that this woman, first of all, recognized that, there was some shenanigans going on in 2016. She says that I have very strong feelings that I don't like Donald Trump. Here, you're not sure. She says, I'm not sure if I could be impartial, right? You answered that you strongly dislike Mr. Trump in your questionnaire, but she's on the jury now. So, unfortunately, I think that this trial is probably going to be very, very political. I think that based on what we have seen, it's going to be very difficult for some of these people to flip and indict Sussmann when throughout this entire trial, we hear ad nauseum about Trump. So that's what we had yesterday. We concluded with a full jury impaneled. We started the trial today knowing that they were going to be calling a bunch of witnesses, but we really didn't get far in it at all. All we got today were these 3 witnesses. And the first 2 are actually from the FBI. We've got David Martin we're going to hear from. We have Scott Hellman. And then in the afternoon, they brought Steve DeJong in, and he's a New Star employee, which is exactly where Rodney Joffe, the tech executive, works. Remember, Rodney Joffe's over on this side of the mind map. Rodney Joffe, we see down here. I added an entire new branch for New Star. This is the actual company that Rodney Joffe worked for. He was the CTO, the chief technical officer of this organization, and he was responsible for conferring with the researchers, Georgia Tech, and everybody to concoct this entire collusion scheme. He worked for New Star. The other gentleman that we're going to hear from, Steve DeJong, was also testifying today. So he actually took the bench and came out and talked about DNS records and all of that, which we'll break down shortly. But another researcher has invoked his Fifth Amendment right. So we see here Manos, which was another researcher listed in I think the original indictment. He is not going to be testifying. He invoked the Fifth Amendment, and so nothing from him. But we've got today the 3 witnesses we're about to hit. I know this is sort of a long overview, but we've got tomorrow a whole slew of additional witnesses who are scheduled to come down the pike. We've got Deborah Fine, Laura Sego. She was also over at Fusion. Mark Elias, the Democratic heavyweight there for their legal team, and then many others. Jim Baker with the FBI. Robbie Mook was a Hillary Clinton campaign advisor. Robbie Mook is not going to be called by the prosecution that we found, but the defense is very likely going to call him. So, all right, without any further ado now, we know where we stand. We've got our bearing straight. We've got the mind map under our belts, is that the phrase? And we can jump into the transcript. So as usual, all 4 parties from both sides are there, prosecutors and the defense. Shout out to Lisa for these amazing court transcripts. We see that the witnesses, we've got an index here. We've got the 3 witnesses that we just talked about. 2 witnesses here on the morning session, David Martin and Scott Hellman. These are 2 FBI agents. And the people doing this, the direct exam and the cross-examination, going to be Brittane Shaw. She's a prosecutor. And we actually had a photograph of her. She's the only prosecutor who has a photograph here. This is Brittane Shaw. And then we see that Bosworth is going to be doing the defense, I think the opening arguments, as well as most of the cross-examination of all of the FBI witnesses. So these are the parties that we've got here. Let's dive into it. We know that bright and early this morning, courtroom deputy, probably Miss Jenkins still, said, good morning, Your Honor. We're on the record here in the case of Sussmann. The judge says, good morning, everybody. Give me a second to get situated up here. He's fussling around over here, putting that robe on. It doesn't fit right. DeFilippis, the prosecutor, says, good morning. We're all here announcing, and look who is here. Look who made the entry. Court says, good morning, everybody. Mr. Durham, welcome. I didn't say hello yesterday, which is very rude. We know John Durham is this gentleman here. We can see him on the screen. So I have a couple images that I can throw up on the screen from time to time, just so we can make sure we keep tabs on who we're talking about. So a prosecutor says, just a couple preliminary matters we want to talk to you about. Dr. Manos, the person that I just explained previously, he invoked his Fifth Amendment right. We also want to flag for the court that Miss Corey Arsenal, our paralegal, will be sitting at the counsel table. She's going to serve as a summary witness, and we want to get the court's permission. So some movement of people happening. All right, thank you. Judge says, all right, well, I think we got a couple straggler jurors here. So with 16, that may be more of a problem. And there's a couple of additional evidentiary issues on my plate. DeFilippis says, Your Honor, briefly, these are the first issues that the defense has flagged. Main issue is about a motion about Special Agent Martin. They say that he should only be allowed to testify about certain things. And remember, we spent a lot of time hashing through that in our motions in limine. These were our preliminary motions that both sides filed. The defense really does not want this FBI special agent to go off into the weeds. They really don't. Remember, they want to keep this thing as narrow as possible. The prosecution wants to expand the scope out as far as they possibly can to make this look like this grand conspiracy. Hillary's involved, DNC's involved, everybody's involved. Chuck Schumer's sitting there just doing what's the guy from The Simpsons? Mr. Burns, right? He's very evil. And they're all just plotting on this. And there's this whole conspiracy that they're trying to uncock. That's the narrative. The other version that the defense wants to proffer is that there is nobody other than this being a misunderstanding involved. So they're talking about Special Agent Martin. They're talking about what they're going to allow him to testify to. And we'll get to that, right? We're actually going to hear what his testimony says. So we'll see what that sounds like, sort of what they hashed through. They're talking about whether a case agent is going to be able to dig into what the FBI looked up. And so I want to jump into the testimony sooner rather than later. We have the court talking. All right, so the court says, okay. There's a reference to testimony about spoofing the data. Okay, remember the data was a big question here. And the judge largely said they can't talk about most of this. When we went over to the mind map, the judge said, I don't want to get into the weeds with this technical stuff. It's going to confuse the jury. Is there going to be any testimony that this data was spoofed or that the FBI analyzed the data? And the prosecutor says, yes. And the judge says, well, what does spoofed means? What does that mean to us? Because I told you we can't get into the weeds. DeFilippis, the prosecutor, says, all right, well, let me explain this, Judge. Spoofed, Your Honor. It's the concept that it's always a possibility when you look at the DNS data that it was intentionally created to create the appearance of lookups or transactions between the two computers, right? The concept here was that Rodney Jaffe, tech executive number one, was encouraging his researchers to create an inference that would be useful to VIPs at the DNC, right? We have documents that confirm that. So if Jaffe is very excited about this, maybe they can just make it up. Maybe they can just spoof the whole thing. So the prosecutors want to talk about that. They say that FBI special agent's going to come in. He's going to testify. Your Honor, he's going to talk about all this type of evidence. He prepared data. He doesn't use the word spoof, but it might have been intentionally generated or it might have been fabricated is what he's going to say. That was the FBI's initial conclusion too. So he's making the argument. He says, Judge, look, if the jury needs to understand the course of this FBI investigation, well, they got to understand these concepts. The judge says, well, but let me ask you about this. Did the FBI ultimately determine that the data was fabricated in any way? DeFilippis, the prosecutor, says, well, Judge, it ultimately did not reach a conclusion on that. But says, as you know, the CIA, and the court says, all right, but that did not bear on its conclusions that the allegations were not substantiated. Prosecutor doesn't like where this is going. So he says, Your Honor, I think we'll have to ask Agent Hellman about this. It's certainly part of the mix. You know, the lack of visibility into the authenticity of the data is problematic. And so the judge is getting irritated a little bit, says we spent a lot of time on this counsel talking about data accuracy. And this strikes me as now getting into whether the data was falsified or not, right? Whether it was real or not, whether it was spoofed or not. And with the defense's representation that it's not going to suggest that there was a link based on that, I thought that at least to me, that sounds like it might be out of bounds, right? And this is sort of one of those frustrating rulings that as, you know, an outside observer, it's like, I really would love them to get into this, but I understand the judge's perspective because the charge here is about the lie. And, you know, I forgot to mention this, but I was on Viva's channel. Very thank you to Viva Fry, who is our neighbor on Locals and on YouTube. And so make sure you're following his channel. Of course, he's covering all sorts of stuff. And we were talking about this. And, well, let's continue. Let's go back to the transcript. And I think this will continue to make sense. But he says, Your Honor, I'm sorry. We understood your ruling to be that the FBI's conclusions as it went along were okay as long as we weren't asserting that the conclusion was in fact fabricated. So we can't get too deep into the weeds on this. You know, I mean, it's difficult to chart the course of the investigation. The court says, all right, Mr. Bosworth, I'm sorry. Mr. Bosworth goes over to the defense. The defense comes out and says, I think the colloquy you were just having gets to the central concern. It's too deep into the weeds. They're using the ruling that they can to get to ultimate conclusions about what the FBI said. And what the conclusions were, does it go to the materiality of the lie? The actual lie is about Sussmann sitting down with the FBI saying, I'm not here on behalf of anybody else. in fact, being there for Hillary Clinton, right? Actually went back and billed her for the whole thing. The concern here is that if they start offering testimony on when data can be fabricated, this whole thing can spiral out of control. So the court says, are you going to contest any of that? It says, I'll allow testimony about statistical shortcomings or contours of the data, but I'm not going to allow to talk about whether it's fabricated or spoof. So not allowed to use those words. All right. So go ahead, he says. Your Honor, and the defense can deal with that in cross. They go through. Is there any objection to paper coming in? And they're still battling over some of these preliminary issues. Let's see if we can get to some of the actual testimony. We'll fast forward here a little bit. They're talking about Mr. Elias. Now, this is going to be very good testimony, and I think he's scheduled for tomorrow. Prosecutor is saying they're going through the different actual sort of intended progressions here. And they're saying, Your Honor, with Mr. Elias today, they didn't get to him today. We may elicit broadly his role in the course of a retaining fusion. So remember Mark Elias, right? Everybody sort of peered for this guy to see what he testifies about or how he does. He is this fellow. We didn't spend much time here with him at the start of the video. Mark Elias was general counsel. Somebody who was very high up at Perkins Coie, literally Hillary Clinton's campaign lawyer for the 2016 election, and very involved in all of this going on. So they don't really know. Obviously, he's not going to be cooperative with the prosecution because he is Team Democrat, but they are talking about what he's going to talk about, and so I want to spend a minute on this. It says they're going to talk about the Steele dossier, and again, without going into any specifics. And then finally, Your Honor, we would likely through an FBI agent seek to either elicit or offer into evidence the dossier report that references Alpha Bank. All right, so they're still hashing through preliminary stuff. Let's get into some testimony if we can. And again, the judge is just saying, look, I'm going to reserve on this. Don't open on Steele. I'll allow you to ask Elias about the meeting. I'm not inclined to let in the dossier. I want to go back and read the testimony about how the information came to the FBI. All right, so, this is all preliminary stuff, and the prosecution is recognizing sort of how in the weeds this is getting. He says, Your Honor, I apologize. Look, just two very quick factual points because I just want to make sure the court has an accurate understanding. It is not the case that the dossier came to the FBI through British intelligence. Dossier, and we were talking about this on Viva's channel today, dossier did not come through British intelligence. Mr. Steele gave it to an FBI agent in Rome, and it made its way from that agent to FBI headquarters. Mr. Steele, we understand, was in communication with Fusion GPS, but it did not come through British intelligence. And we already have that sort of connection mapped out here in the mind map. If we take a look, we can see down here, this is Fusion GPS. This is Christopher Steele. The Steele dossier is the Trump PP paper, which I have linked here if you actually want to review it. But it sounds like they're having conversations about this. This was the dossier that was used to get the FISA warrant to go after Carter Page, which was one of Trump's campaign advisors. So a prosecutor clears this up. Court says, all right, well, let me ask this question. Can the government provide any evidence that the report was given to Bill Priestep as part of the Oppo research, or did this come through another source? So Bill Priestep was, again, over in the FBI, and you can see, man, we can get into the weeds on this. So I want to get into the testimony. Otherwise, we can spend probably a full hour on this, just dissecting these preliminary issues. But the reason why this stuff is important, but it's all sort of conversations about what might happen and how things intend to go. And so, a lot of the time the judge will just reserve this until it's actually in front of them, right? Until the issue pops up, then they'll deal with it. But the judge, two things, says one, Ms. Sego is going to testify today or tomorrow. She's going to say that she met with Christopher Steele. Laura Sego was an employee for Fusion GPS, and say that they did, in fact, hire Mr. Steele. So Fusion was the consultant working for Perkins Coie, and Fusion hired Mr. Steele. Secondly, the very same testimony that Berkowitz just cited of Christopher Steele in the overseas proceeding said that the first time he learned about Alpha Bank was when he met with Sussmann, and that Mr. Sussmann told him about the allegations, and he testified immediately that Fusion GPS tasked him to write a paper, wow, about Alpha Bank. Okay, so this is going to be good. All right, now none of this is coming out today, but tomorrow that's going to be Miss Seago, and you can see all of this being connected. Basically, Sussmann is having conversations with Steele, and I think what's happening here is two people are coming together from this at two different angles. You've got Christopher Steele, who has this whole, Trump-Russia PP tape thing going on, and then you've got Michael Sussmann, who separately is investigating a separate thread where he's talking about Alpha Bank and Russian collusion, and they are brought under one roof when Fusion GPS brings them together. And they say, oh my goodness, you've got this Alpha Bank stuff. That's amazing. You've got this Trump PP tape. That's amazing. Maybe we can put these two things together and come up with an inference. And that's going to be, I think, how this all unfolds. Vienticus Prime is in the house, says, where's the Rumble stream? Well, I didn't start a Rumble stream today. It's a little finicky to sort of run multiple streams together. We tried that. Maybe I'll be able to do that, Vienticus, tomorrow. I'm just not sure that there's enough of a demand for that, unfortunately. But yeah, I can throw that up possibly tomorrow. But thank you for the support, Vienticus. And Vienticus gave me some very good advice yesterday on Twitter. He said, Rob, don't end the show so abruptly, right? Just because you look sort of goofy when you're trying to put the camera lens on and it doesn't end. It ends before it should. I think you get the point. But thank you, Vienticus, for that support as well. So we go back to the transcript and we fast forward. Is the jury ready? The judge says. Deputy says yes. Court says, all right, we're going to bring him in. I'm going to give him the standard instructions and we will get started. Good morning, ladies and gentlemen. You all came back. I hope you had a good evening and you're ready to go. Before we begin with the opening statements, I'd like to give you a few preliminary instructions just to explain how this trial will work and what we're going to be doing for the next 2 weeks. Don't talk about this. Don't go on Facebook. Your notes are going to be locked up yesterday. As I noted yesterday, there are 16 of you, but there are only 12 are going to be deliberating on this case. Usually there are 2 alternates, but because of COVID, we've got 4. I'm not going to disclose to anybody who the jurors are or alternates are until the end of the trial. I explained yesterday, this is a criminal case. Defendant Michael Sussmann being tried on a single criminal charge, willfully and knowingly made a materially false statement to the FBI, stating that Sussmann knew that he was not acting, or he stated that he was not acting on behalf of a client. Turns out he was acting on behalf, at least the allegations say, of 2 clients, one being Rodney Jaffe, the other being Hillary Clinton. To prove the offense, the government must prove beyond a reasonable doubt. You should understand the indictment is not evidence. Every defendant, which is true, deserves the presumption of innocence. If the government proves every element beyond a reasonable doubt, then we are able to convict him. Otherwise, not guilty. Now, we have the prosecution coming up first with their opening statements. And we have Britain Shaw. Remember Britain Shaw, just so that we know who is speaking now. And I asked Viva if I should do sort of a feminine voice or something like this, like in an audiobook. And he recommended against that. He said it's pretty dangerous to be experimenting with that stuff, especially on a live stream. So don't do it. And I said, that's probably a good call. But remember that we have Britain Shaw. It's this woman here. She is a Durham prosecutor. We know a little bit more about her, actually. And I clipped this from her LinkedIn. She was somebody who went to George Mason University, the Antonin Scalia Law School. Oh, which is a pretty conservative former justice. Also a law clerk for Judge Royce C. Lamberth. And Royce Lamberth is a pretty conservative fella as well. I think he was appointed by Reagan. So she actually is a prosecutor, right? She might be somebody who happens to be conservative. I don't know. But just based on some of that lineage, maybe. Anyways, she's up. She's ready to deliver the prosecution's opening statement. And remember, when we talk about openings, we're always looking for a theme. What is the theme that each side is putting forward? And when we talked about this with Ghislaine Maxwell, and just because I said that name, this video is now going to get flagged on YouTube. Great. But here, in that case, they talked about remember the 3 words they used? Money, memory, and manipulation. Really good job. There was nice alliteration, $10 million, come up with those words. Money, memory, manipulation. And I think I still remember it from, 7-8 months ago. Let's see if we see any of this coming from both sides of this trial. Thank you, Your Honor. Ms. Shaw says, good morning. My name is Britain Shaw. I'm joined by my co-counsel here. And says, thank you, Your Honor. Oh, so this is introducing. Trial will proceed. So they got introduced, so they actually have not started yet. They're still going through their instructions. Third stage, instructions on the law. My responsibilities are to run a fair trial. All right, let's get to openings already. Come on now. Miss Moira here is our crack court reporter. She's going to be taking everything down. You're going to have a transcript of the trial back with you, all right? Now, we're going to begin with the opening statement from Ms. Shaw. Thank you, Your Honor. Government prosecutor now stands up. Let's see what she's got for us. She says, ladies and gentlemen, the evidence will show that this is a case about privilege. There's our theme. The privilege of a well-connected DC lawyer with access to the highest levels of the FBI. The privilege of a lawyer who thought that he could lie to the FBI without the consequences. The privilege of a lawyer who thought that he could be powerful and the powerful normal rules didn't apply, that he could use the FBI as a political tool. Ladies and gentlemen of the jury, on September 19, 2016, Michael Sussmann, a high-powered DC lawyer, went to the FBI bringing serious allegations about a presidential candidate on the eve of an election. Serious allegations about secret communications with a foreign adversary. But when the defendant walked into the FBI headquarters on Pennsylvania Avenue, the evidence will show that he bypassed normal channels. He went straight to the FBI General Counsel's office, the FBI's top lawyer. He then sat across from that lawyer and lied to him. He told a lie that was designed to achieve a political end, a lie that was designed to inject the FBI into the presidential election. What was that lie? The defendant told the FBI, their general counsel, that he was bringing them information about a presidential candidate on his own, not on behalf of any client, but as a good citizen. But the evidence will show that wasn't true. The defendant wasn't there as a concerned citizen. He was doing it not for one client, but for two. The opposing presidential campaign and an internet executive. He lied to direct power to serve the ends of his client. Now, as the judge just told you, the defendant is charged with one count of false statements to the FBI, and the government's evidence is going to show you beyond a reasonable doubt that he's guilty. And so let me just tell you what the evidence says. Well, we're going to show you that back in September, powerful attorney named Sussmann texted his friend, James Baker, who was an FBI general counsel. Like I said, it's top lawyer, right? If you don't know what general counsel means, ladies and gentlemen of the juror, let me help you, all right? It's their top juror, the number one person, the top lawyer over there. He texted Baker on Baker's personal cell phone and asked to meet Baker the next day. And we have that in the mind map. You can see that next to James Baker in the mind map. The actual text. He told Baker that he had something time sensitive that he wanted to give the FBI. Let's just take a quick look at it while it's here. Now, we're going to see a lot of this. And so, I'll try not to pull this up all the time and sort of interrupt the flow. But this is a very important one. James Baker is right here. Here is the text message. It says, Jim, it's Michael Sussmann. I have something time sensitive I need to discuss. Do you have availability for a short meeting tomorrow? I'm coming on my own, not on behalf of a client or company. Want to help the Bureau. Thanks. All right. The defendant went on to write in this text that he was coming on his own. He just wanted to help. You will see the text for yourselves, like we just did. You will see that these are the defendant's own word. Now, Mr. Baker had known the defendant for a long time. They worked at the DOJ together. That's why they agreed to meet. They were buddies. He agreed to meet with him on an urgent basis because he trusted him. But the evidence is going to show that when Sussmann met with the FBI, that is when he committed the crime charged here. The defendant lied to the FBI's faces. He told Baker that he was not there on behalf of any client. He just wanted to help the FBI. That's the false statement. I'm not here on behalf of anybody else. There it is. The evidence will show the defendant then proceeded to tell Baker that he had received information and the data that supposedly showed a secret channel of communication between Trump and Alpha Bank, the Russian bank. Sussmann told Baker that cyber researchers had discovered this secret channel. The evidence is going to show that Sussmann gave Baker 2 thumb drives containing the data as well as white papers from the allegations. He gave him these thumb drives and left. You're also going to hear from James Baker that after the meeting, after he sat down with Sussmann, he came away thinking Sussmann had given this information to him because he was a good citizen, not on behalf of a client. You're also going to learn that Baker and other high-ranking FBI people promptly opened a case and directed an investigation towards these allegations. Donald Trump, an incoming potential president, was colluding with the Russians? Of course the FBI is going to investigate that. They opened an investigation that would later find the server was merely a spam email server that was used for sending out marketing emails. The server did not reflect a crime, nor was it a threat to national security. But this is what Sussmann was banging the table about. But there was a crime in all of this, the lie to general counsel. He said he wasn't there on behalf of a client, but the evidence will show two clients, Hillary and Rodney. Now, before I talk about the evidence, the prosecutor writes, let me address the proverbial elephant in the room. I wonder what this could be to a DC jury that at least 3 of them literally donated to the DNC. I wonder what the elephant in the room is. What could it be? Well, it says some people have very strong politics and about Russia, and many people have strong feelings about Trump and Hillary. But we are not here because these allegations involve either of them, nor are we here because the defendant's client was the Clinton campaign. We are here, though, because the FBI is our institution and should not be a political tool, not for Republicans or Democrats or anyone. So whatever your political views may be, they can't be brought to your decisions that you're going to be making in this courtroom. So you see how they're getting away with sort of addressing that, saying that this is a call to the higher ground, right? The high ground maneuver. You might be a Republican, you might be a Democrat, you might be a DNC supporter, but that's okay. That's okay. We want you to exercise your political opinion and all of this, but you got to leave that stuff at the door, right? What we're talking about is a lie to the FBI, and regardless of your political disposition, you don't want anybody lying to the FBI and trying to use them as a political tool, do you? That's why I'm encouraging you to not bring it in. Your task in this trial is straightforward. Your role is to consider the evidence and the law. It's really that simple. What's the evidence going to show? Well, it's going to show that the defendant's lie was part of a much bigger plan. And we'll see how much of this we get into. A plan that was carried out in concert with 2 clients. The Hillary Clinton campaign. Are the tentacles really going to go that far? And Rodney Jaffe was a plan to create an October surprise on the eve of a presidential election. A plan that used and manipulated the FBI. A plan the defendant hoped would trigger negative news stories and cause an FBI investigation. A plan that largely succeeded. Now, if you're a Democrat on this jury panel, you're sitting here, your blood's just boiling, right? You're just going, wait a minute. This Trump-Russia story's fake? You're going, what? Huh? First time I heard this, they thought that was all true. This prosecutor was just shaking them to their political cores now. The other people are saying, I have no idea, I'm not plugged in, but never heard about this case. Yeah, that all sounds perfectly reasonable. We know from the jurors that I looked at previously, I didn't see anybody who had allegedly donated to the Trump campaign or the Republicans. So the prosecutor continues, says, how did the defendants execute this plan? Sussmann and Perkins and Hillary and Rodney. What'd they do? Well, they went through their 2 clients. First, we have the Clinton campaign. You're going to hear that in the summer of 2016, as the presidential election was heating up, the defendant was working at a major DC law firm as legal counsel for Clinton. That was Perkins Coie. You're also going to find, as part of this, you're going to hear part of their campaign efforts that they were that they hired Fusion GPS for what they called opposition research. Now, she says, opposition research, yeah, it happens in politics all the time. Republicans do it, Democrats do it, nothing wrong with that. But you're going to hear about this company called Fusion GPS, what they were doing. And through this, their investigators and researchers were digging up any dirt they could possibly find about Donald. And when they found something that was dirty, they would plant it with the press and ultimately with the FBI. Okay, it wasn't like we're going to blog about what we found through our opposition research. They're going to use their tools, their leverage at literally the FBI and the Department of Justice to plant this seed that Trump is colluding with Russia. October surprise right before the election. Ms. Shaw continues. She says, you're going to hear around the same time that Jaffe and others were conducting their own kind of opposition research, but it was a different kind. Jaffe was a high-ranking executive with an internet company who had interest in other internet companies. This is how she's explaining DNS. You will learn that Jaffe and one of his companies used the defendant as their lawyer, hired Michael Sussmann, and that they paid the defendant and his firm over $1 million per year. Big money. The evidence will show that given his position at these companies, Jaffe had access to vast amounts of internet data and traffic that included the DNS system. You will learn that the DNS data is basically a digital trail that's created when computers look each other up on the internet in an effort to communicate. It's part of the trail that we all leave when we send emails or surf the web. And I was curious as to how she was going to explain this, right? Because this is a complicated topic. And when you start to get into the weeds on a lot of this, oftentimes jurors' eyeballs will just glaze over, right? You see this oftentimes in DUI cases, which our law firm represents, by the way, over at rrlawaz.com. Link is down in the description below. We love helping good people charged with crimes. And she's not doing that. She's not engaging in that. She says, the evidence will show that in the summer of 2016, Jaffe and others started using their access to huge amounts of traffic to conduct opposition research, right? They got access to private data, and they were using it for nefarious purposes. They started looking at the internet and any information about online activities of Trump. Jaffe gave this data to Sussmann, the data that they would later claim showed that Trump was in fact communicating with Russia. The evidence here, ladies and gentlemen, is going to show that Jaffe and the defendant knew the server was a spam email server. They were concocting this whole story. But they also claimed it was being used as a secret communications channel. Now, the evidence will also show, and this is becoming very prosecutorial, isn't it? The evidence will show, the evidence will show, the evidence will show, the evidence will show. That's what prosecutors do. And it's kind of tedious. Now, the evidence will show that the defendant saw this supposed data as a golden opportunity to deliver a big win. Remember, he was going to please the VIPs. You're going to learn that Sussmann put Jaffe in touch with the top lawyer for the Clinton campaign. And he also connected Jaffe with Fusion GPS and the research firm. He arranged calls and meetings between the two. So what she's describing here is just this connection. Basically, Sussmann here is interfacing with all of the different parts. Sussmann sending emails to Mark. Sussmann sending emails to Fusion. Sussmann's communicating with these guys. Glenn Simpson, Peter Fritsch, potentially, right? I don't know. Rodney Jaffe over at Newstar. Christopher Steele, even potentially, they're having meetings. He's texting Jim Baker at the FBI back and forth all over the place. And so Sussmann's sort of right at the center of this giant conspiracy. Says that's where the defendant's plan took shape. First, oh, here it is. Oh, look at our alliteration. Look at this one. Remember on the other trial we covered money, memory, and manipulation. Look at this one here. The evidence will show that the plan had 3 parts. Oh, perfect. A look, a leak, and a lie. Oh, how fun is that? We got 3 L's. A look, a leak, and a lie. All right, well, let's analyze that for a minute. A look. So I'm not real sure I like the first L, but I do like the last one. L, a lie. Yeah, a leak, a lie. It's complicated. You know, Maxwell's team, they paid millions, tens of millions of dollars to come up with those 3 M words. But this is pretty good. I'll have to say it's pretty good. That's our theme for the trial. Durham prosecutor says a look, a leak, and a lie. Let's see if we can suss out what's happening here. Suss it out. The evidence will show that as Sussmann and Jaffe met and coordinated with representatives, they looked for more data. You will hear Jaffe instructed people at his companies to go and find derogatory information about Trump, make ties to Alpha Bank. Fusion GPS did the same thing. And second, that was, I guess, the look. First, the look. Second, the leak. So the look is they're all looking around and trying to go find this evidence. They're scouring the internet. They're combing through it with a fine-tooth comb, trying to gobble up whatever they can. But second, we have the leak. You will hear from the evidence that the defendant Jaffe then leaked the Alpha Bank allegations to a New York Times reporter. Could that be Eric Lichtblau, who we talked about yesterday? Expected he was going to run a story about it. And then third, we have the lie. You will see that when the reporter didn't publish the story right away, the defendant and others decided to bring this information to the FBI. Can you believe this? So Sussmann sends this over to these reporters. These reporters are like, are you stupid or something? This doesn't make any sense. None of this is vetted. So he says, well, I'll take it to the FBI. They'll believe me because what the hell do they know? And he also did that to create a sense of urgency, tell the FBI that a major news organization was going to run the story within days. So once wow. So they were playing both sides essentially. Okay, they would take this to the media and they would say, hey, this is a story we're taking to the FBI. It's going to be vetted. Why don't you run with it? The reporters are like, this looks like garbage information. They go to the FBI and they say, hey, FBI, you got to do something about this. Why? Because these journalists are going to publish this story about this any day now, and it's going to jeopardize national security. So you better get onto it. So they're playing both sides of this thing to create a sense of urgency in both directions. That's when the defendant requested the meeting with the FBI and told him he was not doing this for any client. The evidence will show that the defendant had at least two reasons to lie. Wonder what those could be. First, you're going to hear the defendant was a cybersecurity lawyer, was hired earlier that year by the DNC to represent them in relation to a computer hack where they'd been the victim. Now, all of the Democratic donors on the jury panel are sort of scratching their heads. You mean this whole case involves the DNC and they just heard that name out there now? Because of this, the defendant was in frequent contact with the FBI about the hack, right? Hillary's emails got hacked. They brought in the FBI. So now Sussmann is buddy-buddy with everybody there at the FBI. They're having conversations. They considered him to be the DNS, the DNC attorney for that matter, right? Sussmann worked for the DNC for the Hillary hack. Because they viewed him as the DNC lawyer for the hack, the defendant knew that if he came in and told him he was representing a political candidate weeks before an election, they might not meet with him right away, let alone open an investigation. Okay, so Sussmann had an absolute incentive to lie, because if he told them the truth, they would have said, wait a minute, what? You have this PP dossier from Hillary's team. You want us to run with this? We're not interested in that, Sussmann, which is why he said, I'm not coming on behalf of anybody else. I can vet this information through other sources that are not a part of the campaign, even though they were all a part of the campaign. This is the lie. Second, Ms. Shaw says, the defendant knew that if he could get the FBI to investigate the matter and reach out to the press to try to stop the story, that would make the story more attractive to the press. And they would report on it, right? If the FBI is looking into this, the press is going to go, well, the FBI is looking into it. Now, all the while, ladies and gentlemen, the evidence will show the defendant was billing his time on this project to the Clinton campaign. This is the point that cracks me up so much about this whole thing. It's like, hey, you dummies. Can you just not bill her for that meeting? Can you just not get paid on that? What do you charge? $700 an hour or something like that? 2-hour meeting. Okay, it's a lot of money. I get it. But on this one, when you're trying to concoct a conspiracy, do it pro bono, okay? Just defer that, deduct it, or whatever you got to do, whatever you guys do over there. I don't know. You will see the billing records that show that instead of being a good citizen, the defendant was billing his time to a client. The campaign was literally footing the bills. So great. And so when the defendant walked these allegations into the FBI, he wasn't saying he wasn't doing this for any client. That was obviously false. It was false. The defendant personally billed his time to Clinton. It was false because he was bringing these allegations on behalf of Rodney Jaffe. Afterwards, you're going to hear the defendant doubled down on this lie. 5 months later, the defendant got himself into another meeting with the government. This time he went over to the CIA, brought them the same thing. You're going to hear that in setting up that meeting, the defendant told a retired CIA employee that he was seeking a meeting on behalf of a client. So in that one, he was communicating that he actually was there for somebody. But you're also going to hear that during the actual meeting, he told the CIA he was not there on behalf of any client. The same lie the defendant told to James Baker. So not only did this guy do this once, this is very, very interesting, right? Now, I want to pause on this for a moment. This is interesting. So I didn't catch this up until now, but I was wondering why the CIA meeting was so relevant. So oftentimes, let's think about this in the context of another criminal case that maybe we are familiar with. And I think I've told this story once before or not. But there are certain types of crimes. Often these involve a man becoming, overly physically aggressive with a woman to the point where it is, non-consensual, right? I don't want to use the words because of YouTube. But you hear those types of cases. Now, oftentimes prosecutors will investigate those cases. There's a case of R, and the prosecution is now having to figure out, did that individual do it, yes or no? And if the only evidence is really a he said, she said situation, oftentimes, and maybe there's no, real physical evidence, it can be a complicated investigation for a prosecutor to move forward on, right? It really can. But what prosecutors will do to make up for this is they will stack these things together. Is they'll say, well, this individual now, instead of just one victim, he said, it's he said, she said, and she said. And therefore, we can say there's enough similarity between these different incidents that we can infer that this person has, a guilty mind. And it was actually, if we can prove the actual act, right, that these things happened, then we can also say maybe the person's guilty mind is enough to secure a conviction on all three. So this is something that prosecutors do. Here, one of the defenses was that Sussmann, this whole thing was a misunderstanding, right? Him and James Baker, the FBI, they have been communicating for months. They've been trying to get to the bottom of this WikiLeaks hack and all this stuff. And so they're just buddies. And this was all just a misunderstanding. And what happened was memories got shifted. Memories are bad. People lost sight of how this all works because a lot of time has elapsed. We're now in 2022. This happened in 2016. And after the meeting, they're saying that other people were reporting, no. Sussmann, James Baker just didn't remember this right. Sussmann actually said that he was there on behalf of a client. Baker just reported it wrong. So they're trying to isolate this as one incident. Now, the problem for Sussmann is just like in our example involving the R, right? He's got other incidents that very much match the same underlying offense. He also, not that he's being charged in this case about this, but he also went to the FBI and did the same thing. He did it months later. And in the meeting, we're going to hear that he's also lying at that moment in time as well. So now if the jury wants to chalk this whole thing off as just one, aberration, a big misunderstanding, the government, just like in our other example, is going to slap another incident and say, it's the same pattern. It's the same thing. So hopefully that makes some sense there, but that's what they're doing. CIA is going to back up what we've already explained. Says this was not a mistake or a slip of the tongue, right? This was not confusing. It was a concerted effort to conceal his clients and put forward a narrative. Finally, we're getting to the close of her opening statement, says, I also expect that you're going to hear that the defendant actually got caught in his lies when he was required to testify under oath before Congress in December of 2017. And when he testified under oath, he was specifically asked about the meetings with the FBI and the CIA. And during that testimony, he admitted that he'd carried out both of these meetings on behalf of an anonymous client. He was referring to Jaffe at the time. In other words, the defendant gave Congress something he had not given the FBI, something that he hid from them. So when he shows up for a formal congressional subpoena, he's saying one thing to the FBI, saying a different thing. Also different from the CIA. But the evidence will show that the defendant hid something from Congress too. He wasn't even honest with them, which is when he approached the FBI's general counsel that day with the Alpha Bank allegations. As the election was approaching, he billed time on the matter, not to an unnamed client, but rather to Hillary Clinton. His own sworn testimony will prove he lied to the FBI and that he is guilty in this case. So what's the evidence? How are we going to prove this to you? Well, let me tell you about this. You're going to hear some evidence out of order. Testimony from the witnesses may not be chronological, just dealing with the scheduling conflicts and things. So it's little like air traffic control, but you are going to hear it all, not just in the order I'm about to tell you. We're going to have three types of evidence, and she's going to go through documents, physical evidence, and of course, witness testimony. She's going to sort of explain this. Let's see here. Is this worth going through? Yeah, it probably is. You're going to see that the defendant put his lie in writing, the 42-word text to Baker the night before the meeting where he said he wasn't coming on behalf of anybody. You're going to see in black and white his billing records that show he literally billed his work to Hillary Clinton. You're going to see emails and phone records that show that the beginning of the summer of 2016, he worked with Fusion GPS to develop this whole story and plant it in the press. Very fascinating legal work. Interesting. You can just make up things and bill political campaigns for millions of dollars, apparently. You will also see internal FBI records and emails that show you the defendant's lie mattered. Okay, it was material. It misled officials into thinking he was a good citizen or acting as a good citizen. They took steps and devoted resources to uncover a spam server. You're going to hear testimony from witnesses, FBI General Counsel Jim Baker. You're going to hear from other officials who Baker briefed. That's Bill Prystep and Tricia Anderson. We've covered their notes here at length. You're also going to hear from the agents who investigated these allegations and what they did. You're going to hear from an FBI cyber expert who is going to explain DNS data, and he was the first witness today. Employees from Jaffe's company, Jaffe tasked with researching the internet. That was another employee today. Hear from Fusion GPS people. You're going to hear from the defendant's former law firm, Perkins Coie, about their billing procedures. And we've got a lot of physical evidence as well. We've got handwritten notes from the two people that met with James Baker. Those are the notes in the mind map. We've covered both of those. That's where they said that Sussmann said that he was not there on behalf of another client. You're going to take a look at two thumb drives that come in that Sussmann gave to Baker. They were loaded with data in the white papers, and they were also show that he charged them to the Clinton campaign. So he billed them for the thumb drives. Oh, it's funny. You know, in Arizona, we have, I'm not sure if this is still a procedure, but when I was doing more of the discovery pickups, I was picking up evidence from, in our cases, I would go down to the Maricopa County prosecutor's office downtown, and they would say, if you don't bring a CD-ROM, right, like a CD-ROM, a blank CD-ROM drive to exchange essentially, nobody even has those in their computers anymore. They would send you a bill for like 15 cents. They say, we gave you your evidence on a CD-ROM and you didn't leave us another CD with us. Okay. We're going to have to bill you. Send me a bill. 15 cents. All right. Send it over. We'll pay it. And it's just one of those things. Because what kind of lawyer wants to carry around extra CD-ROM drives in their briefcase when they're schlepping around to court? Nobody does. Anyways, enough of that. So now before I sit down, the prosecutor says, I want to go back to where I began. This is a case about privilege, circling back. Let's see if she goes back to her alliteration. Let's see if we remember what her alliteration is. Do you remember the 3 L's? Let's see. No one should be so privileged as to have the ability to walk into the FBI and lie for political ends. Ladies and gentlemen, whether we are Democrats or Republicans, whether we hate Donald Trump or like him, we have to agree that some things have to be above politics. One of those things is our law enforcement agencies, and the other is the truth. After you've heard all of the evidence, you're going to know what the truth is. The defendant lied to the FBI, and it wasn't a trivial thing. It was not a mistake. There was a breach of trust that happened here. The FBI should never be used as a political pawn. Thank you very much for your attention. The government is going to have the opportunity to come back and speak with you again at closing argument, and you're going to hear Judge Cooper explain the law. If you carry out your duties, the only verdict that is consistent with the law, the defendant is guilty. Jurors are sitting there scribbling away, and they're saying, oh, yeah, okay. Yeah, that's interesting. All right. Well, the Democrats are shocked on the jury. They're going, what the heck kind of trial is this? I mean, they're obviously saying not guilty right now, but let's see if the defense delivers anything else for us. Mr. Bosworth is now on deck. And Mr. Bosworth, we know, is this gentleman here. The defense, of course, we have a lot of photographs for. Mr. Bosworth is here. He's over at Latham and Watkins. This is the defense team. He's coming out after Ms. Shaw just finished, and he says, all right, it's my turn. And may it please the court. Says Michael Sussmann didn't lie to the FBI. Comes out with a very powerful first statement. Michael Sussmann wouldn't lie to the FBI. If we're thinking about the FBI as our institution, there is nobody who would agree with that statement more than Michael Sussmann. All right. Michael Sussmann didn't lie to the FBI. Michael Sussmann wouldn't lie to the FBI. If we're thinking about the FBI as our institution, there is nobody who would agree with that statement more than Michael Sussmann. So I don't know what that really means, actually. But all right, he says Michael Sussmann is a serious national security and cybersecurity lawyer. For over a decade, he worked right alongside the FBI as a federal prosecutor. So I think he's trying to imply that Sussmann is saying that the FBI is our institution, right? So when he was out there in his opening arguments, he was probably, if we're thinking about the FBI as our organization, there is nobody who would agree with that more than Michael Sussmann. Here's why. He used to be a federal prosecutor. He's worked alongside the FBI as a national lawyer in private practice for over 2 decades, top security clearance and all that stuff. And in the summer of 2016, this serious national security lawyer got information that raised serious national security concerns at a time when questions were swirling about Donald Trump. One of his longtime clients, somebody he knows very well, Rodney Jaffe, who you heard a little bit about, came to him with information saying there was a weird connection between Trump and Russia. A Russian bank owned by Vladimir Putin's closest associates. Oh, that's good. That's pretty good there for the defense. You have to acknowledge that. That's pretty masterful, right? What is Vladimir Putin's name doing in here? Well, Vladimir Putin's causing World War III. And all Michael Sussmann was trying to do was avert more Putin influence. He knows his jurors. Most of the jurors have the Ukraine flag on their Twitter profiles. Like, we know that. Not officially, but if I had to guess, all right, of the 10 that we have data on that I was able to suss out, how many jurors have Ukrainian flags out of the 10? 6? 7? I'd say definitely 7, maybe more than that. I don't know. Rodney Jaffe, they write, is no internet executive, okay? He's one of the world's leading cyber experts. He's not some dork out there who's just, muddling around on the internet, like coming up with a story, who started an internet company. He's a leading cyber expert. Oh, so don't listen to what the prosecutor told you, jurors. He's one of the leading experts on DNS data, the very stuff at issue in this case. He is so trusted that our government, our institution, see what he's doing? The FBI is trying to identify with this. Don't get mad at Sussmann. This was a misunderstanding. Asked him to be a confidential informant for the FBI. The same FBI in question here. That's how much they trusted him. That's how much they relied on him. The FBI and Sussmann are two peas in a pod. And you think Mr. Sussmann got $1 million of business from Rodney Jaffe's companies? Rodney Jaffe got tens of millions of dollars from the federal government, giving them advice, selling them DNS data. Rodney Jaffe knows DNS data inside and out. And when he came to Michael Sussmann with that information, Sussmann took it seriously. And Sussmann agreed with Jaffe to make this public. Jaffe's just this tech expert, obviously. He comes across this information. I don't know what to do with this. I better send this over to my lawyer who can properly advise me on what I should do. And he does that. The plan from the start was to go public with serious information so that the American people could decide for themselves what it showed. That was the plan, to go to the press. And that's what they did. They went right to the top. There's nothing wrong with that. What you didn't hear is that they took that information to a Pulitzer Prize winning reporter at the New York Times, who we've talked about yesterday, Eric Lichtblau, who is now filing a protective order so that he doesn't have to disclose any of his sources or really testify. He was going to write a story about it. He met with Mr. Sussmann. He met with Mr. Jaffe. He researched, because that's what reporters do, and he was going to write a story about it. He was going to go public. And if Sussmann hadn't spent a career working alongside the FBI, if Sussmann didn't care about the FBI, we wouldn't be here at the last minute. Because at the last minute, when Sussmann knew and heard and believed that a story was going to run about this, what did he do? He didn't keep his mouth shut. He didn't let the story come out. He went right down to the FBI. He was a hero. All of this got leaked out. It wasn't Fusion GPS sending the story to anybody. It all leaked out. And Sussmann wanted to make sure the genie didn't get out of the bottle and cause a bunch of Russian madness, I guess. So he went to the FBI to settle it. And he went to the FBI to give them a heads up that it was coming. He gave them, to tell them that this story was coming so they wouldn't be caught flat-footed, so they wouldn't be caught by surprise. He went to the FBI to help the FBI, which is exactly what Sussmann said he was going to do in the text message that started this whole thing off. They got to get rid of that bad evidence. Now, you heard the evidence is going to show that this meeting was all about the Clinton campaign. You are going to hear the meeting with the FBI is the exact opposite of what the Clinton campaign would have wanted. Was the Clinton campaign generally one of Sussmann's clients? He's saying, yes, it was. Of course it was. Was the Clinton campaign a client on this effort to get a story in the press? Yes, there was. There's nothing secretive about that. That's what they do. But this FBI meeting was something very different. Okay, all of that other stuff the prosecutor was talking to you about, it's irrelevant. Stop trying to make this hula hoop expand out beyond the proper scope. This meeting is something very different. Forget about all that other stuff. The FBI meeting was something they didn't authorize, they didn't direct him to do, and they wouldn't have wanted him to do. The Clinton campaign had nothing to do with this. nor did the DNC, because he wasn't there for them. So at least there's some consistency. The defense says, because you know what happened? Well, as the evidence will show, when Mr. Sussmann went to the FBI, tell them this story, the FBI effectively shut it down. The exact opposite of what the Clinton campaign would have wanted. They want a big story that hurts Trump. And Sussmann, by going to the FBI, shut that all down. He was there to help the FBI. So the prosecutor was saying that they were playing both sides. The defense is saying no. He was legitimately, honorably going to the FBI saying, guys, there's this big story coming out. Warning, warning, red alert. Shut this down before it gets out of hand. And that is the right legal thing to do. So the defense says, so what are we doing here? The government's theory doesn't make sense. The evidence will not support this charge. And today I want to walk you through that evidence. I want to talk to you about the evidence that I think will show and evidence what it will not show. And I want to do it by focusing on 4 key questions. Let's see what these are. First, what did Sussmann actually say to the FBI? I'll answer that. Second, is what he said false? Third, did he intend to say something false? And fourth, did it matter? Now, these are going to be this is very, very nice work here. This is going to be basically the different elements of the crime, right? Probably see a lot of this language ripped off right from the jury instructions that they're working on. But, you know, stuff like this, did it matter, right? Is it a white lie or is it a material lie? Because what if he went in there and said, you know, I can dunk a basketball. And Jane Baker is like, you? Really? Okay, well, anyways, why are you here to see me there, Michael? And if it's not material, then it falls without of the scope, right? Fourth, did it matter? So, okay, maybe all of this. Second, is what he said false, right? So it's not a lie if it's actually true. Did he intend to say something false? Even if the words that came out of his mouth are false, was that his intention? No, this whole thing was a big mistake. And so now we're talking about sort of a mental state, mens rea, right? This is all very, very good work. He says, look, to convict Sussmann here, the government has to prove beyond a reasonable doubt the answers to each of these questions. So let's run through them. Here's how I want to use my time. Briefly talk you through the storyline and ask those questions. So let's get started. First, Mr. Sussmann. Now, I told you a little bit about him, but I want you to hear a little bit more about so you understand him. Put aside that Sussmann's a good man or a family man. You're going to hear that Sussmann is an honest man. He spent 12 years working for the DOJ, went to Perkins Coie private law firm. They've been around for over 100 years. And at Perkins Coie, he was a prominent national security lawyer advising all sorts of clients. Through that work, he interacted with the FBI at the top levels. He trusted them. He had top secret clearance. They trusted him. That's why he was communicating with the FBI. He even had a special badge that allowed him to walk in and out of the FBI, just like an employee. So if they trust him, ladies and gentlemen, you have to trust him. You must. His whole livelihood depended on his credibility. You know who else had a relationship with the government? Rodney Jaffe, internet executive, leading cyber expert. He was also a confidential FBI informant, had relationships and got tens of millions of dollars for DNS data. That's how much the government trusted him. These two people are just amazing, good United States citizens. So in the summer of 2016, Mr. Jaffe, this expert, came to Sussmann for help. All sorts of questions flying around at the time about Donald Trump and Russia. And when Jaffe told Sussmann what he had, there was even another tie. There were these weird lookups going on. One computer trying to find where another computer lives on the internet and tries to look up the address and try to figure out where it's going. DNA data is he says that's what DNA data is in my non-expert understanding, which I think what he means is DNS data. All this evidence showed there was some weird stuff going on between Trump and Russia. And Mr. Jaffe came to Sussmann and said, please help me. How can I get this public? Well, and why would he help? Well, he's a lawyer. It's his job. And Jaffe and Sussmann knew each other. They trusted each other. They've worked for a long time. And third, Sussmann had his own experience with Russian interference in the election. A few months before that, Hillary got hacked by the Russians. A lot of initials in this case. Those are some of them, right? DNC, FBI, so on. You're going to hear that when Russians hacked the DNC, Sussmann became the lawyer. Sussmann agreed to help as soon as he got the data. And they analyzed it. But was Sussmann involved in gathering the data? No. The evidence will show he didn't even analyze it. He didn't know there was a spam server. He says, this is what DNS looks like. You'll see during the trial. It should be up on your monitors. And so I can't see what obviously he's showing. But the judge says, can everyone see? Whether you see it or not, or still can't make sense of it, there's a jumbo of numbers and letters. And what is at issue in this case is that thousands of pages like this kind of look like gobbledygook. It takes a cyber expert to understand this. In fact, as you heard, it's so complicated, the government is calling a special expert to explain this to you. And where's he going with this? Michael Sussmann is just a big dummy. He doesn't know better. He didn't analyze it. He doesn't know what DNS data is. Okay, he's a lawyer. He's smart about the legal things. And can help people get stuff public. But he's not somebody who really knows that this is a fake, concocted story. That's what the DNS expert does. And both of these guys are extremely trusted by all the three-letter agencies around the world. It says Sussmann wasn't involved in any of this. And what he was involved in was helping make this public. So he went to Mark Elias, one of the partners at his law firm, and you're going to hear about that. He knew that the Clinton campaign would benefit from the story. That's true. The Clinton campaign was one of his clients. And because the Clinton campaign would benefit from the story, because they were aware, he treated them as his client and he billed them as his client. So now they're going to address the billing. There's nothing remarkable about this at all. That's just how it works. And by the way, the reason that these bills show up with Sussmann's entries to the Clinton campaign is because Sussmann himself billed those entries. He showed, I'm doing work for the Clinton campaign. Hardly the sort of thing that you would be doing if you were trying to keep it all a big secret. It was just obvious. Everybody knew. Sussmann wasn't trying to hide anything. He billed for it. So then what happened? Well, they tell us. So you'll hear there's not much left to the story at this point. That right around Labor Day, Sussmann went to the New York Times to pitch the story. He reached out to Eric Lichtblau, Pulitzer Prize winning story, met with them. Lichtblau was working on a story and about to publish this. That's when we get to the FBI. At the moment, not when he's frustrated with the story, when he believes the story is imminent, it's about to come out. That's when he meets. You're going to see that on September 18th, Sunday, Sussmann received an email freaking out, saying the Trump campaign was freaking out about a story coming out in the New York Times. Story seemed imminent. What happens 2 hours later? Sussmann's text goes out. He sends this over to Jim Baker. Says, oh, Trump knows about this. It's going to go public. I've got to do something to head this off at the pass. That's when Sussmann realizes he has to reach out to the FBI and gives them a heads up. He tells the FBI and Baker in the context of the text that he wants to help the Bureau, which is exactly what he did. Next day, they sit down for less than 30 minutes. Baker didn't even take any notes at the meeting. Don't know why. You'll hear Mr. Baker didn't record it. Mr. Baker didn't write a report of the meeting, which is what FBI agents live to do. Nothing. And there's no one else present in the meeting either. No recollection, no recording at all. Very, very nice, right? At the meeting, Sussmann told Mr. Baker that there's a big story about to come out. Didn't ask for anything in return. Here's the information it's based on. And that was the meeting, the first of a couple interactions they had later. They give us a clip. They play a short clip here. Obviously, we don't have that. Mr. Bosworth plays the clip. A conference for privacy professionals. Sussmann interviewed Mr. Baker, right? So they're playing this clip of Sussmann and Baker palling around at some conference. Mr. Bosworth then, after the video clip is over, says, privilege? Oh, like that's privilege? Says, no, relationships. It's not privilege. That's relationships. Relationships matter, especially in the small world of national security lawyers. Like these are two national security lawyers. They all hang out with each other, just like the lawyers on YouTube hang out with each other, right? It's LawTube. Here it's National Security Tube or whatever, Ask yourselves, after you hear the evidence and you see Mr. Baker, do you think Mr. Sussmann would throw his career away, his life away to tell a lie to that guy? So they have this meeting on September 19th, that Monday. There are no notes, no recordings, no reports. Series of interactions happen later. The text happens on Sunday. The meeting happens on Monday. There's a phone call on Wednesday. Phone call on Thursday. Contact. Okay, they're talking all over the place. And notably, none of the contact was recorded. No notes of any of that. No reports of any kind. No witnesses at all. You heard that after Mr. Baker met with Sussmann, some other people took notes. Other people. They're not going to be able to explain them. You'll see those notes for yourselves. But there are no notes for any of these other interactions or phone calls. There are no notes for anything else. More on that in a moment. Right? He's going to say, what he's going to say is there's not evidence that this actually happened. Going to question Jim Baker's memory, going to try to actually impeach Jim Baker's memory, I'm sure of it, if they can, using those external notes or any other evidence. We talked about the March 7th meeting that took place in 2017 after Trump was, obviously elected. He had his acting attorney general in place. McCabe was there. Strzok was there. Jim Baker was there at this meeting with the acting AG. And they communicated that at that time, Sussman, when he went back and did all this, he did it on behalf of a client. So they just changed their story to make it legal. But we all know that is not true at all. So let me take a quick water break here and see what's going on in the chat. I see Ronnie Cole's here. Just Cause is in the house. Shout out. And we have Sarah's here. Sarah 1776. Jimmy Butler's here. Says, so the second part of the game, yeah, they're all trying to get rid of the evidence. Sarah says we can multitask. Thank you. Sorry to interrupt the show, but we have a couple more, I think, pages of the opening arguments, and then we'll take a look at some of the witnesses, and then we'll be through the morning transcripts. And I think that we probably are not going to get to the afternoon transcripts because I did not get those until very late. But today we'll cover those, quickly tomorrow, just sort of like we did today. But let's go back to the transcripts now that the parched mouth is a little bit resuscitated. So after Sussman meets with them, two things happen. One, the FBI decides we do want to investigate. They reach out to the New York Times. They ask him to hold the story. Story was supposed to help the campaign, but it got shut down. So if Sussman wants to help Hillary, why did he shut down a story that was about to go out? Is basically what he's implying here. The second thing that happens is the FBI investigates. You're going to hear that they did things that the FBI can do, that Rodney Jaffe can't do. They issued subpoenas. They interviewed witnesses. They got extra data and so on. Ultimately, they found, nope, nothing to worry about here. They did things necessary to say, is there any evidence? Is it real or not? They said, no, nothing to worry about. Sussman said there might be smoke. They looked and said no fire, which is what they do with tips. They get day after day. That's what the FBI does. That's the story, saying that he just provided them a tip. They investigated it. Nothing went wrong. No harm, no foul at all. So now let's get to the questions. The first question, what did Michael Sussman actually say? Well, you know about the text message that came out on Sunday, but what about the meeting on Monday and the phone calls later? Well, you heard James Baker is going to come out in here, and he's going to tell you that Sussman said that there was not a meeting, that he was not meeting with me on behalf of a client. But with respect, Miss Shaw didn't tell you that Mr. Baker, tell you all that Mr. Baker has said. What else has Mr. Baker said? And what hasn't he said? Well, you're going to hear that in 2018, 2 years after this, Baker testified under oath that he had no memory whatsoever of whether Sussman was there on behalf of a client. So Baker's testimony is going to change because he's in on it, right? He's part of the whole cabal. You'll hear in 2019, he testified under oath that Sussman did talk about clients. So this was all in 2016 was the real story, right? In my humble opinion. 2017, holy smokes, Trump won. My goodness. We're not going to be able to paper over this whole thing. So at the 2017 March meeting, they come up with the whole story connecting the dots. Oh, no. Sussman did in fact testify or communicate to us that he was there on behalf of a client. Same thing happens now that Jim Baker is sort of, moving out of his old position. He repeats the same thing in 2018. I have no memory at all. I can't remember if he communicated one way or the other. And then in 2019, suddenly he gets his memory back. And now he says, in fact, he did talk about clients. So it all flipped over the last several years. You'll hear that in 2020. So it's going to be a prosecution witness, but he's not really a prosecution witness. He's going to be telling a story that supports the defense. You'll hear that in 2020, he told the special counsel that the topic of whether there was a client never came up, just didn't even happen. Now, they want you to believe Mr. Baker's memory is clear, but you're going to see his memory is about as clear as mud. And is all that surprising? How many of you can remember a conversation you had 6 years ago that you didn't take notes of, that you didn't record, and that nobody else was there for? Hard to do, which is why this trial, of course, is taking place 6 years later, all by design. Hard to remember what you did yesterday, let alone what someone specifically said years ago, and nothing that the government introduces is going to show you, is going to prove exactly what those conversations were. Beautiful, reasonable doubt there, right? Beautiful. This is so far removed. Nobody can remember. Baker's changed his mind 35 different times. I don't remember. Now I remember. Now I clearly remember. He said he brought a client. In fact, he brought a copy of their retainer agreement. And I looked at it and I said, oh, it's very good. So all my notes were just erroneous. Forgive me. Memory is faulty. What a crock, right? In a meeting just months later, the FBI, I think you can see that, was asked to brief the senior officials at the DOJ in the Trump administration. This is where we get that. Sussmann here. Yeah, so they're going to really try to show you those other notes that are in the mind map. Remember, the mind map has this note here that says attorney brought to FBI on behalf of his clients. This was the March 17th meeting notes that is going to potentially come in as evidence or be talked about. Sussmann is charged here with saying the exact opposite. Talking about this important meeting. It shows that the FBI thought as of that point in March that the information did come from an attorney on behalf of a client. So either Baker believed it or Baker didn't care. That's reasonable doubt if there ever was. We'll see about that. Now, I'm not sure that those notes are actually going to come in because remember, those are the double hearsay notes, but there were other things that they could get them admitted by. We covered that yesterday. Next question, is what Sussmann said false? Well, if you don't know what he said, you can't say it's false. But even if you can say that, there is still reasonable doubt about what he said. Also says, use your common sense. If the Clinton campaign really wanted to send in an attorney to conceal his relationship, Sussmann's the last person they'd send. They'd send someone else that the FBI knew represented partisan clients. He was someone that they knew represented partisan clients. So he's going through and just sort of addressing this one by one. He says, third, I'm speeding up. Good, so am I, because I want to finish up. Did Mr. Sussmann intend to make a false statement? The government can't prove that. And what would Sussmann gain by lying to Baker? Nothing. What would he lose? Everything. He'd lose his credibility, his relationship, security clearance, and all of that. For what? Well, probably the idea that Hillary Clinton wins and then he gets appointed to some ambassadorship or something. Ask yourselves, are these the actions of someone who is trying to lie? If he was trying to hide who is behind Alpha Bank, why would he tell Jim Baker that he got the information from cybersecurity experts? Why might that be? If he was trying to dupe the FBI, why did he give them the data so that they could evaluate it for themselves? And if he wasn't motivated by generally love of national security, why did he go to the CIA in February of 2017, months after the election, when there wasn't even a Clinton campaign going anymore? Good question. Well, maybe it's because he needed to double down on his story to paper up after the fact. But it's a good argument from the defense. You will learn he had a genuine interest. Nothing else shows Mr. Sussmann's good intent. Met with the former CIA employees, and so we're going to go through all of that. This is not the effort of someone trying to hide the existence of a client. You'll see at the meeting, Sussmann said, I'm not representing a particular client, but I am there on a client. Look, I'm partisan, something he said. And the last question, did this matter? This is about the materiality, right? If it's a white lie, then it doesn't really matter. It doesn't fit the statute. It's got to be something that leads to materiality. The notes from this file, the notes from the FBI, are littered with references to Sussmann being a DNC lawyer. He's a lawyer representing the DNC and says, judge the FBI by what they did. If the motivation of a source was so important, why? You would think they would have interviewed Sussmann himself. All right, so this is going on and on and on. Ladies and gentlemen, I'm concluding now, finally. And I appreciate your patience listening to the opening statement on behalf of Sussmann. It is essential that you are here because you are here to give the government a fair trial. 4 questions. What did he say? Was it false? Did he intend for it to be false? And did any of this matter? Keep an open mind as this trial goes forward. Don't reach a conclusion till the end. I'll leave you with this. You've got an extraordinary responsibility. In this case, as an injustice, and I suspect when all the evidence is in, you will agree. All right. Opening arguments, both sides. That was the defense closing up And the prosecution had our alliteration was a look, a leak, and a lie. I remember that one. Here we've got the 4 questions. We've got, what did he say? Was it false? Intentionally false? Did any of this matter? Harder to follow along on that one, but this one's a little bit more instructive, right? You've got now actionable information that a jury can sort of can run through a test. What did he say? Here's what I said. Was it false? And they're writing all this down. A look, a leak, a lie. What did he say? Was it false? Did he intend, like intention? And did any of it matter? So I'll have to see what, how this all fleshes out. Now, we are honestly just getting started because that was just opening arguments. Now you'll notice we're about halfway through the court transcripts here today. And we've got about an hour 25 going on the clock. We're going to keep moving forward. We're going to go through basically the rest of this thing because I think that we'll pick up tomorrow with the next witness, which was the New Star agent, De Jong. All right, so we've got here, let me back up a little bit. So now we're going to call our first witness and let me show you who we've got on the mind map. And these are technical witnesses, so we're not going to spend a ton of time on them, but we have these 3 witnesses came out today after opening arguments. We've got David Martin, FBI special agent. He's the DNS expert. That's all of the gobbledygook, as the defense called it. We also have Scott Hellman, FBI special agent, cybercrime and intellectual property. So he's going to be testifying today. No photographs of them. Obviously, they're top secret special agents. And then Steve De Jong is the final employee who came out today. And we'll probably start with him tomorrow. But he is the New Star employee. And I actually didn't pick that picture. This is something that he picked for himself. This comes over from what I believe is his LinkedIn profile. Distinguished New Star Security Services. And he's going to be telling us a little bit more about the connection between Jaffe and New Star to Fusion GPS and then back over to Perkins Coie. But they got to lay some framework first, right? Before we can understand all of this hacking and all of this problematic collusion, we've got to understand what DNS is and how it works. And so, like I said, some pretty technical stuff from what my understanding is on the what happened today in court. But let's see if we can piece together what's happening. All right, sir. Ms. Shaw, Britain Shaw, prosecutors back up. Opening arguments done. Direct examination starts. David Martin, special agent. Will you please raise your right hand, sir? David Martin, I swear to everything. Spell your last name. Martin. Got it. All right. I'm a supervisory special agent for the FBI. Shaw says, what's your title there? Well, I do chief technical analyst. I'm in the CTAU, the Chief Technical Analysis Unit. Been there for 13 years. Any background information that you care to share with us? Yeah, computer science, psychology, minor's degree, went over to Delaware, information security, I've got engineering, digital forensics, all sorts of stuff. And before you joined the FBI, did you work anywhere else? Yeah, I was in Colorado at the Bureau of Investigations there. And you said you've been doing this for 13 years. Let's talk about some of that. I primarily work computer intrusion cases and cases involving minors, intellectual property rights, and exploitation. And is it fair to say that in those cases, when you're involved in this, that you review what's called DNS data? It's kind of important, right? And this is sort of like the phone book of the internet. If you need to, what website do you need to go to? You got to figure out the phone book. You open up, all right, Rob is there here, and you go there. Or like this would be the map. If you want to get to a certain location, you go into your Google map. If you control the map, if you control the phone book, very powerful because everybody's got to go to your phone book to say, I want access to that. And if you're that gatekeeper, you get to say, oh, what do you want access to? That's weird. Is that in Russia? Is that with Vladimir Putin? So he says, yes, I'm a special agent. I'm very smart at the FBI. We actually do some work sometimes. And the investigations often involved examining network traffic. And DNS data was a key part of that. And when we say network traffic, what are we talking about? Well, various computer networks, internet is probably the largest. And I took a job at the cybersecurity division. It's located in Chantilly, Virginia. Responsibilities changed a lot. Similar kind of cases, but you say that you reviewed a lot of DNS. Yes, I reviewed it very frequently. And after that position, you went to another position? Yeah, I moved up again to the response team. 50 agents were scattered throughout the different area. Then I went over to the CTA, which is the Cyber Technical Analysis Bureau, and we looked at malware and viruses and Trojan horses. And at that time, I managed about 70 people. So he's just a lot, managing a whole lot of people. And the court reporter, Lisa, is like, can you slow down there, special agent, I'm trying to get this all down. He says, all right, sorry about that. Yeah, we manage our network traffic analysis. And so, we'll talk about DNS stuff, and continues on. How many agents working there? He keeps going. A lot of this is foundational. I've taken 20 continuing education classes. I have a certification called GIAC. What is that? Oh, it's the Global Information Assurance Certification Group, which means he's very sophisticated. Computer security and technical fields. How many people receive this, sir? Well, less than 200 people in the world. And she says, what? Less than 200 people? I'm sorry, come again? And that's dramatic effect. She heard him the first time. She knew what he was going to say. He says, ma'am, I believe there are less than 200 people with that. She goes, wow, you're very, very qualified. She says, in the world. Okay, thank you. Wow. In addition to your certifications, any awards from the FBI? Yeah, a few different awards, like the Award for Excellence. In addition, have you published any papers? Yeah, some of it. And so she says, Your Honor, this time, we want to certify this guy as an expert. I think he's an expert. The court says, in what area? Well, cybersecurity and DNS. Any objection? Defense? No objection. Fine. Okay, court will qualify Agent Martin as an expert. He can qualify and talk about cybersecurity and DNS data. Tells the court, ladies and gentlemen, there are two types of witnesses you might hear from. There are lay witnesses that know some about the facts, and then there are expert witnesses that we use to help understand what's going on. That makes sense? Okay. Thank you, Your Honor. So Agent Martin, in preparation for your testimony, you got some slides, right? Yeah, I prepared some slides, and also talking about DNS and Tor network, which is just great because we don't see those slides. We're not gonna be able to see what they're talking about. And if I show you the government exhibit 1700, do you recognize this? Yes, I do. And I move to admit it. Third page. Oh, don't get to see any of this. All right. So prosecutor says, all right, so let's start with this. What is the domain name system? He says, and we'll skip through most of this, but let me just lay a little bit of foundation here. So DNS is basically a way to map human readable names of things like Google or Yahoo to numerical IP addresses. So it works kind of the same way. It's a bit more complex, but it works kind of similarly to a phone book, or where it maps a person's name to a numerical telephone number, right? My law firm does criminal defense work. We love to help good people charged with crimes in the state of Arizona. If you want to know our law firm, how to contact them, there's a phone number, 480-729-6280. Oh my gosh, had a mind blank with our phone number. It's in the description below. But in order to connect with our firm, you got to know what the phone number is. You just can't type in R&R Law Group into your phone. It's not going to go anywhere. So there's a translation that happens there. And that's what he's talking about. And before we get into the right side of the demonstrative, how did all of this work? He says, well, when the internet was first started, they would use numbers like 1.2, 0.3, 0.4. And then they needed to start connecting those numbers, interfacing those numbers with actual addresses so that human beings could use them. So they're going through this, right? Looking at this. If you're trying to talk to Mr. Smith, you go down, you find his number, and then you look for the phone number. So there's some sort of graphic there. Go to the next slide. Walk us through how a DNA request lookup works. Is that a lookup? Yes, a DNA request is the same thing. They're synonymous. You got a user on left-hand side, users on right-hand side. Agent Martin, the court chimes in. You need to slow down a little bit for the court reporter, particularly when you're clicking through numbers. Slows down. You see here a lot of this, right, is just sort of an explainer on what DNS is. So the jury understands that. And it's just like I said, it's sort of basically a translation service. So let's see if we can fly through some of this. Talking about Google servers for .com. There's a level above that. DNS server. Next slide, next slide, next slide. Okay. Still talking about .bizes and things. So at this point, the DNS lookup and request is complete. Your computer now knows what the address for Google is, right? We walked through all of that. You put into Google, it says, hey, what is the IP address for Google? Goes out there, gets the number, brings the number back to you, takes you to the number, serves you Google. But it hasn't taken any other steps yet. It actually hasn't connected to Google yet. Okay, so the query is done. Next, then you get the old Google web page that shows up. Passive DNS is capturing a copy of the DNS queries. When you say queries, what is that? Well, it's a lookup or a query. All right, what's on this slide? We get another slide. Then we talk about passive DNS. Some of these are commercial. And here we see Newstar. Okay, so now a lot of them are used on information security. So people who are doing network defense, if they're trying to block spammers, identify hackers, or compromise computers, you can do this at the DNS layer, right? Rather than letting people get to that IP address saying, if somebody sends a bad request to you, I want to access your website, and they might want to access it for nefarious purposes, for spamming you, or, like what is it? A DNS attack. It's a DDoS attack, right? Some of that you filter away at the DNS level. You just say, you don't get to connect to us because it is spammy. There's all sorts of different services that provide these services. And so they're talking about some of them would be companies like Farsight and, of course, Newstar. Yeah, they do this. They keep the phone books maintained. Pull up the next slide then. This is going to tell us about a simplified DNS lookup, passive DNS lookups. They have another connection, DNS for Yahoo. At this point, the jurors' eyes are just glossed over. I'm sure of it. Comma separated, tab separated values. Next slide. Last screen. Can you speak into the microphone? Yeah, sorry. So they're just going through really bland, boring stuff. Put it all in an Excel workbook. Okay. Before we move on to the next topic, what does a DNS lookup tell us in the most basic terms? Okay. Now that we have all that background out of the way, what can we glean from this? It tells you that one computer looked up an address for a particular domain name. The Internet Protocol, that's right. Now, does the existence of a DNS lookup, like what we might see in the logs, does that mean that there was actual connection between the computer? So in your case, your great aunt's computer and Facebook, just because there's a lookup, does that mean there's an actual connection? It says no, it doesn't. There are two separate processes. You can conduct a DNS lookup basically as the first step of another connection, or you can do it entirely on its own. Doesn't mean that they actually connected with one another. And so a DNS cannot tell you whether there were communications between emails. He says no, a DNS lookup cannot tell you that, right? That's going to be a very important line. So all of the information, all of the records that they brought, none of it tells you anything. Got it. Similarly, would an IP address be able to tell you the substance of what's been happening? So even if you did see that, does that mean that Trump and Russia were colluding? No. You'd have to have a different source of data. You'd have to have another source of data to establish whether there was an actual connection and then what occurred during that connection. Multiple different things happening. There's a command in Linux called dig, and security appliances and phishing emails coming from Amazon, right? All of that can be spoofed. One more vocab term. What does visibility mean? Well, it's passive DNS, right? And he's just going to give us a lot more details on this. They turn over to Tor, talking about the onion router. Instead of going directly to the internet, you're going through different servers, sometimes in different countries. Tor keeps a list of all the servers and all the different nodes. He goes through a graphic from the Electronic Frontier Foundation. Next slide, talking about Tor servers. All pretty bland stuff, right? And, this I think is largely necessary, but it is bland. And the jury, of course, is not, I think this is why they're getting this out of the way first, is because the jury, right now the jury is fresh. The jury is willing to sit through some of this stuff and understand some of the mechanics. But if you presented this at the last one or towards the end of the trial, right, they would be done. They'd be tired and exhausted. So that's what we get out of this. Not much, right? He comes to some conclusions. We basically extracted that you can't really tell anything from DNS. Let's see what the cross-exam looks like. You're an expert in this, right? So who's doing the exam? Bosworth's up. You got a master's degree? Yeah. You've got training for a few hundred hours? Yeah. You've got qualifications? Yeah. Cybersecurity, all sorts of stuff. Now, you told us on direct what a DNS lookup is. It's fair to say that at the most elemental level, it's just one computer trying to find another. Yeah, that's basically what it is. That's the only level I can do it, says the defense lawyer. At a very basic level, yes. And the defense lawyer, see, this is kind of the folksy sort of, I'm a nice guy approach to the jury. Well, I can't understand it. I can only understand it at the basic level. Everything you just talked about confused the hell out of those jurors. And so let me empathize with those jurors. Let me say that I also don't understand it. So they think that we're sort of alike. And it doesn't, for example, show that emails go back and forth. He says, yep, that's correct. It doesn't show any emails that might have been exchanged. Nope, no emails either. I mean, any cyber expert would know that fact, right? And the FBI cyber experts would know that fact. Yep. And actually, to figure out if one computer is connecting to another, you would need more information, right? Yep. And you could use subpoenas and you could do all of this. So you see what he's doing now is he's trying to show that the FBI was the only entity that could do anything about this. So let me show you what I mean. Here he's saying there are only things that the FBI can do that a private citizen can't do. I couldn't do that. Only the FBI could do that, which is exactly why Sussmann went over to them. He knew that this was a problem, but he didn't know the extent of it, which is why he went over there. And only the FBI is capable of moving forward on those action items, right? Right. So that's why he went, is what he's saying. Law enforcement officers can issue search warrants to figure out if one computer is in fact connecting with another. So DNS might give you a hint, but then the FBI can use the leverage of the FBI to dig in further. Judge issues the search warrant. They can request a search warrant. FBI gets access to the data at times. Do you know a guy by the name of Rodney Jaffe, sir? And he says, yeah, I've met him before. You've met him before? Yeah. So I take it you know him? No, I wouldn't say I know him, but I've met him on a few cases. And he's also a DNS expert too, right? He says, yeah, that's my understanding. He's someone who's highly respected and trusted. Well, he's well known in cybersecurity. And are you aware that he and his companies maintain contracts with the U.S. government for millions of dollars? He says, no, not specifically. I mean, I know there are some contracts, but not the specifics about them with Newstar. Were you aware that Rodney Jaffe even had patents in the DNS data? He's such an expert, he patented some of this stuff. Oh, yeah, I believe I heard that before. So you're an expert, and he's an expert. Oh, this is very interesting. And he founded companies that specialize in DNS data. And it's fair to say that in 2016, that was respected, right? So as far as I know, FBI was respected. And he's someone that the FBI relied on, right? And he said, I would say that I don't know. I'm sorry, sir. What was your last answer? Your last answer. Martin, he says. No, your last answer. Oh, sorry. As far as I know, sorry, the last question was, I can rephrase it. So even he's tired. Sir, what was your last answer? Last name's Martin. No, what was your last answer? Oh, well, I don't remember. What'd you ask me? Okay. Mr. Bosworth is continuing on. Are you aware that Jaffe was a confidential human source? So basically the rest of this is about to sort of support Rodney Jaffe to make him look like he's a bigger expert because he's going to come in and try to refute some of this stuff. You weren't part of the FBI team that investigated any of this. No, I wasn't a part of it. Just to be clear, you don't know what Sussmann does or doesn't know about DNS data, right? That's right. And you weren't there at the meeting? No, I was not at the meeting. Any other questions? No. Okay, so Ms. Shaw comes back out, and I typically gloss over the redirect. Well, we do get an objection here, so let's see what we have here. Okay, so she says, Mr. Bosworth asked you about Jaffe. Do you know whether he is still a confidential human source? Objection! We get our first objection from Mr. Bosworth, and the judge says, what's the basis? Judge says overruled, so I guess he didn't maybe give a basis. And the witness says, what? Huh? Judge says, you may answer to the extent that you know. He says, no, I have no idea. I don't know whether he's still a confidential human source. So that begs the question. Is Rodney Jaffe still a confidential human source? And is he hanging out with Ray Epps somewhere in Queen Creek, Arizona? Don't know. Good question, though. Are you aware that Mr. Jaffe was closed for cause as a source? No. Shaw says, I've got nothing further. Right? So that's the end of that. So that is the first special agent, the first witness, done and in the can. We have our next witness comes up. Court excuses him. Don't discuss your testimony and get out of here. Okay, ladies and gentlemen, feel free to stand up and take a stretch if you'd like. I know those chairs aren't always quite as comfortable as they can be. So we'll do that same thing right now. We'll sort of, loosen up a little bit. DePhilippis is coming out next. And DePhilippis, don't have a photograph of him. So I won't go over to the mind map. But he's going to do witness number 2. And let's see what he has for us. Court says, all right, did you get your water break, Rob? Are you hydrated? Yeah, Judge, sorry. Thank you for the break. All right, are you all set? DeFilippis says, yes, I'm ready. Okay, go ahead. Your Honor, the government calls Special Agent Scott Hellman. All right, Mr. Hellman. Step right up, sir. Feel free to remove your mask, remain standing, raise your right hand. Do you swear? Yes, I do. Good morning, sir. Can you spell your name? He does. Where do you work? FBI. I'm a supervisory special agent. Ooh. I don't lead my own investigations any longer. I lead a team of investigators who investigate the crimes. Now, over the course of your career, you've done a lot of work, right? Yep, 14 years of time, same thing. All sorts of background. We'll fly through most of this. Cyber hacking, cyber crime, stealing something, trade secrets. And the FBI is divided into divisions, right? Like cyber division, and you've got a wide range of things you do. Is there also a counterintelligence division? Yeah, it's right next to the Where's Waldo division where they investigate Lego sets that look like that from the January 6th insurrection day. And briefly, what does the counterintelligence division do? Well, it's certainly not my area of expertise, but they gain information through a variety of means. And are there cases in which the cyber division and counterintelligence division work together? Yeah, sometimes there are. And how do you know about the DNS system? Well, very basic level. Same thing, right? These are two pieces of computers talking to each other. I was also based in Chantilly. It's about an hour away. That was in September. Let's see. Okay, here we go. Now, did there come a time in your career at the FBI when you learned about information that the FBI received concerning a supposedly secret channel of communications between Trump and Alpha Bank? Yes. When was that? Well, September of 2016, right around the time of the meeting. You remember the beginning and the end of the month? You remember a date? Yeah, September 19th specifically. Oh, perfect. That's when Sussmann met with Baker. Now, in getting ready to testify today, or I think it was right around that time, have you reviewed documents, records, emails, and the like? No. And when you testify to dates, are you basing that on your memory? I refreshed my recollection. I learned about the information because it was provided to James Baker. Who alerted you to this information? My supervisor did. Supervisor was Nate Batty. Okay. And were they in the cyber division? No, they weren't. Now, this is where, this is going to be some good stuff, I think. Chain of custody. Okay. We talk a lot about this. Now, in a DUI case, so let me give you a real example. In one case, I was able to get the blood results in a DUI case thrown out. Why? There was no proper chain of custody. And what we talk about is you have to be able to document where that blood comes from every single step away of the investigation, from it coming out of your arm into it being introduced as evidence. You got to be able to show that. In one case, there was a problem with the officer who transported the blood, right? In other words, there was an integrity problem with this officer. The person who drew the blood, perfectly good. That's person A. He gives it to person B. Person B transports the blood down to evidence, goes to person C into the evidence locker. Then, you have the forensic scientists and all these people, they call themselves, the forensic lab. They pull it out and they do the actual analysis. Well, what happens if the handoff from A to B or from B to C or from C to D is bad? Then that whole sample, in our opinion, is now tainted because that person who transported the blood could do something to it. They could mess with it, right? They could heat it up, or they could tamper with the labels, or they could swap labels, or they could relabel somebody else's sample. I mean, there's a whole slew of things that they could do. And so if that happens, then you can say that everything that results after that chain should be thrown out. It should be booted away. And in this case, they're going to be talking about that same concept, where in a DUI example, like we do at our law firm, we try to preclude the evidence in a way that brings us good benefits, right? Obviously, if that blood result is thrown out, it's a problematic blood result. That's good for the case. Same thing's happening here, though. And the question is going to be, where did this dossier come from? The chain of custody. This special agent's going to talk to us more about it. It says, in terms of chain of custody, what does it mean? Well, you collect a piece of evidence. You want to make sure you track exactly who had custody over it. And it's a piece of paper, essentially, that A signs it, gives it to B signs it, gives it to D, and so on. They hand the evidence to somebody else. They also have to sign it. And says here, is it commonly done when evidence is collected? Yeah, it is, because the evidence has to have integrity. Now, that we know what that is, she says, in this case, I was just asking you about Alpha and Trump. Did you play any role in the chain of custody process there? Yes, I did. I did get some of this stuff. What'd I do with it? My role was to obtain signatures from people who had custody over the evidence, some of which were the thumb drives. Did you do that by yourself? No, I did it with other people. And who were those people? Well, it would have been Nate, my supervisor, somebody else named Jordan Kelly. Did you all do that on the same day? On September 19th? Did you take those thumb drives all on that day? No, we got signatures for the chain of custody the next day on September 20th. Why was that? Well, the thumb drives were at FBI headquarters. We were in Chantilly. We drove down the next day, got the thumb drives, and then got the signatures on them. When you say we drove out, who drove out? Well, it was me and my supervisor, Nate. And we got to know that, because what happens if these guys, start tampering with the thumb drives or tampering with the evidence, or the defense gets their hands on these thumb drives and they say, this data looks like it's corrupted, looks like somebody manipulated it. Well, they got to go back to the chain of custody and say, who had it last? Nate had it, or Special Agent Hellman had it. So the prosecutor says, I'm going to show you this exhibit 282, which is probably the chain of custody document. Yep. What is it? It is the chain of custody that we have on this. So we're following it from person A to person B. Do you recognize it from your involvement? Yes, I do. Offer it as an exhibit. No objection. Admitted. There are a number of boxes here on this document. You see those? Yeah. And in the upper right-hand side, it says signature of the seizing individual. Can you describe what that means? Well, the first person to receive the evidence. Who was that? Oh, here it is. James Baker, general counsel for the FBI. Thumb drives, white paper, the dossier. Of course, Sussmann gave it to Jim. Is that the individual you mentioned before? Yes, that's who I thought got it. And describe for us how one interprets the evidence and what they do. Well, we're reading left to right. And it literally looks like sort of we can't see it on the screen, but it looks sort of like a chart, right? You say, you sort of connect. It's a log. It's basically a log. I can't draw it on this slide, but it's a log. You put it in. I gave it to this person. You document the time, document the location, badge number, all that stuff. So it says you relinquish custody. That means you gave it to somebody else. Yep. One person hands it off to somebody else. Second row on the left, he relinquished custody. So who did Mr. Baker give it to? Oh no, it's Peter Strzok. Oh no. That's Peter Strzok. Remember Peter Strzok. He is one of the FBI lovers who was having an affair on his wife. Shame on him, who was actually sending text messages to Lisa Page. Lisa Page was the other FBI lawyer who was, I don't know if she was married or not, but her lawyer is Amy Jeffries, who is the lawyer, my understanding is the lawyer for the DC Circuit Court judge. My understanding. That's the rumor there. And I don't know. Apparently I didn't link the source on that. Okay, so here's what we see. So let's just piece this all together. This thing is so scandalous. It's unbelievable. So Michael Sussmann meets with James Baker. James Baker, they have the meeting September 2016, gives him those documents. Baker then sends those documents over to the FBI, and I put Peter Strzok somewhere in here. Where is Peter Strzok? Where'd you go? Well, I don't know where he is. I thought I put him in here, maybe not. But he needs to get added because he is now on the list. All right, so Peter Strzok was the other side. Yeah, I can't find it. Was the other person in the texting FBI lover story saying that they were going to stop Donald Trump. Unbelievable. Let's see here. We have another one. A super chat just came in from Brett Nia. Says, I feel so at home listening to network inspection and detection talk. Most unbland stuff in the world. So I think that's a sarcastic comment, but I appreciate that, Brett Nias. Yeah, hopefully this trial picks up a little bit. The DNS stuff is very dry, which is why it's kind of good they're getting it out of the way, because I think the jurors are going to have glossed over, honestly, just sort of like we did here. But it is important foundation. But then, after this is out of the way, every other witness is going to be talking about how the communications were working on the back of this foundation. So we know that Baker takes this, gives it to Peter Strzok, who's totally compromised. Do you recall what position Strzok had at the FBI? Well, I believe he was in counterintelligence as well. And who did he give it to? He gave it to somebody else called Eric Spohr. He's an executive at the cyber division. And then it goes to Nate Beatty. That's his supervisor. What's your understanding of what is your understanding of the materials that came in? What did they consist of? Well, technical data, website names, domain names, data explaining the conclusions about whoever came up with the conclusions. And after returning to the chain of custody and returning to that, did you actually go to Baker's office to get his signature? Yes, I did. And other signatures you said were handled by others. I was able to get a signature from Baker, Spohr, but Peter Strzok was not available. Someone else got his signature. You went to Baker's office. Did you talk to him? I do remember that I was frustrated. Here, this is good. I remember being in the office, but I don't distinctly recall what the conversation was. I do remember, though, that after the fact that I was frustrated that I was not able to identify who had provided the thumb drives, the information to Mr. Baker. He was not willing to tell me. Baker won't tell him where these thumb drives came from. Why might that be? Because he knows that if you knew where they come from, you would find them to be lacking in credibility. You'd say, this came from Clinton's lawyers. Why are we wasting our time on this? If you look on the chain of custody form, says the prosecutor, you have to write where it came from, right? He says, no, not on this form. Sometimes you do have to record that. Yeah, sometimes. We call that a green sheet. And then we've got testimony about where the thumb drive comes from and all of this. And so, do you know whether or not Mr. Baker told others where he obtained the materials from? No, I do not. Okay, so once the materials have been logged, were you asked to do anything in particular? Yeah, two different tasks. One, look about the data, identify anything about what's known about the cyber equities, which means criminal charges. And by that, was there any allegation of hacking? So do we see any cyber equities? Do we see any hacking? That's what the cyber division does. So there was an allegation that somebody had been hacked. That was first. Second was to review the data and provide an assessment about what we thought about the narrative that it came with. Who worked with you on this? My supervisor did. Now, what principally did you rely on to do your analysis? First, the technical data. They introduce another exhibit. What is it? It's the summary or narrative that came along with the document, right? So this sounds like it's the actual report that Sussmann was providing, right? It's the white paper, more or less. I want to direct your attention to the paper. What's the title of this? It says White Paper 1, Auditable V3. There's a heading here that says findings. What does this say? Would you read for the jury what it says? Absolutely. So this is actually coming from the white paper. It says, quote, the Trump organization is using a very unusually configured, quote, secret email server in Pennsylvania for current and ongoing email communications with Alpha Bank in Moscow. Through another unusually configured server, a Tor exit node at Spectrum Health in Michigan, right? So it's going from Pennsylvania, Alpha Bank, Moscow, Tor exit node, and they're using a healthcare company in Michigan. Servers are configured for direct communications between Trump and Alpha Bank. The only plausible explanation for this, showing Trump organization is using multiple sophisticated layers of protection to obfuscate their recent email traffic. Prosecutor says, okay, thank you. Does that accord with what you remember the gist of the allegation was that you were analyzing? You read that? Does that ring your bell? Yeah, that's about it. And when you did your analysis, did you look at the data itself in the underlying paper? Yes. Okay. And you wrote an 18 or 19 page document, right? You recognize this? No. Yes. So here he says, yep, this also came along with the narrative. It's log data. Okay. So this is all on the thumb drives. You testified about this earlier. It looks like these different fields. We have this one email address, mail1.trump-email.com, saying that that email domain is a secret communication channel. Go back to the paper, Exhibit 217. They're going through these documents sort of bit by bit. It's hosted by a Pennsylvania company, which is a well-known CRM. It's a customer relations management software that sends marketing emails to tens of thousands of people. Okay, so it's just a regular bland CRM software. Okay, so tell us how you went about doing your analysis. Well, I identified if there was any real hacking. Then I looked at the data. And what did you did this together? He says here, why did you do this together? Well, what did your analysis here, generally speaking, find? Answer from Special Agent Hellman, after reviewing the white papers from Michael Sussmann, says, we did not agree with the conclusion in the paper. We did not agree that this data represented a finding of a secret channel of communication between Trump and Russia. What were the reasons for that, says prosecutor? First, well, I felt that whoever had written the paper had jumped to some conclusions that were not supported by the technical data. So even the information they provided wasn't valid. Number two, I felt that the methodology that they used, the methodology they chose was questionable to me, or it was not a way that I would have chosen to go about it. And I feel like it was a roundabout way to go about doing it. So it was like questionable. It's like they were trying to make it fit. And number three, just overall looking at the overall conclusion they come to was that they had found a secret communication between Trump, the Trump organization, and Russia. What? That just didn't make sense to us because we're looking at a domain, not a country. Like, that's not Putin that he's communicating. It's a domain. Why would a presidential candidate put their own name in a domain name, the supposedly secret domain name called Trump1 mail server, in a domain name that was easily connectable to the organization? And then why would it be the computer be connecting directly to another computer in Russia if this was all supposed to be secret? It doesn't make any sense. So that piece of it, it's just, it just didn't ring true at all, they say, because it's totally fake. Prosecutor says, well, you testified earlier. I think your first reason was that you disagreed with the conclusions. Can you explain that a little bit more? Yeah, so in one example, the special agent says, I believe the researchers or whoever wrote that paper said they attempted to connect with the Trump email server or the purported server, and that the Trump server returned error messages. And from that, they were assuming that Trump email would only communicate with certain devices and not theirs. So they tried to connect, they got rejected. They say, oh, that means they only must be connecting with Russians. And that didn't make sense to me. It was sort of like if I knocked on your door and you told me to go away, I don't want to talk to you, then I'm going to assume that you're only willing to talk with other people. I can't make that assumption. Somebody comes to your door, you get rid of them. It's like, oh, well, I guess if Vladimir Putin came to your door, you'd answer the door for him, wouldn't you? I didn't say that. I just said I don't answer the door. Take it easy. I don't know if you're willing to talk to anybody, right? But that's not what they had done. When they received an error message, they assumed the computer wasn't willing to talk to them, and there was no evidence to support that. So the prosecutor finally asks, if we set all of that aside, putting aside the authenticity of the data, do you agree with the paper's conclusions in terms of what the data showed? No, I do not. Why not? Well, the data itself, there was not enough data to make the conclusion that any communication was happening between Trump and Russia. And I want to show you exhibit number 247, what you have up there. That's a summary of the document that Special Agent Batty and I drafted together. What does it say? How long did it take you to write this? In a day. We did it really quickly. Any particular reason why it was done so quickly? Well, we analyze data, draft these summations, and send them over to Chicago. And we can do it pretty quickly. All right. Can you read the first paragraph that you wrote here when you and Batty were talking about this? Yeah, here's what I wrote. A, assessment of the provided white paper from Sussmann and supporting document on the thumb drives. Summary. ECOU assessed there is no CYD equity, meaning no hacking, in this report, and that the research conducted in the report reveals some questionable investigative steps taken and conclusions drawn. This opinion is drawn from the following observations. Okay, first, on terminology, what is ECOU? What's a cyber division? What is CYD? It's a cyber division. It says that you came to this conclusion. You're talking about the methodology. Yep. And you're saying that there's no evidence of a secret channel, right? No evidence. Let me direct your attention to the last page of the document. And the court now steps in and instructs us, tells us, ladies and gentlemen, some of this is going to be redacted. You're going to see a lot of this throughout the trial, but don't let that encourage you to go one way or another on this thing. Special Agent Hellman, start reading this. Says, furthermore, it appears suspicious that the presumed suspicious activity began 3 weeks prior to the stated start of the investigation conducted by the researcher. So they're saying that the Sussmann people, they only started investigating this, or I'm sorry, they only found evidence of this communication, of this collusion, just happened to be 3 weeks before they started the investigation. It wasn't happening. Oh, we started looking for it and then it suddenly showed up. Perfect. We found it, he says, to be very conveniently coincidental that someone was looking for suspicious activity between two computers and they started looking and they found that activity that just started 3 weeks prior. Very coincidental. So the timing of their investigation seemed like it was a little bit weird. He says, okay, read the next sentence. He says, finally, it appears abnormal that a presidential candidate who wanted to conduct secret correspondence with the Russian government would name the server mail.trumpemail.com, use a domain called trumpemail.com, communicate directly with Russian banks' IP addresses, and it just doesn't make sense. I think you testified earlier that the facts don't suggest secret communication of any sort. Trump was in the domain name, and it just doesn't make any sense. So he gives us some more definitions: OPSEC, operational security. What does this mean? It means that the alleged communication was happening fairly directly between these two domains. Having worked investigations in the past involving Russian cyber capability, we believe that Russia would have a much more technical capability to hide communications if they wanted to. And if they were to be secret, that Russia would have the ability to hide those communications. They wouldn't be so overt about it, right? The Russians are not dummies. So we looked at the top part, and it just doesn't make any sense. What did you set out and what did you conclude? It looks like they were looking for domains associated with Trump. They were just trying to find it. And then they wanted to find, well, an initial set of domains, and then they kept trying to make the connections. In other words, did you express a view as to whether this was a good way to go about this project? He says, no, we did not. I did not feel that that was the most expeditious way to go about identifying the servers. And a lot of this gets back into the technical stuff, STMP and all of it. Oh, we have an objection here. We have an objection from Berkowitz. Let's see what the question says. Prosecutor says, and what, if anything, did you conclude about whether you believe the authors of the paper about whether they were conducting an analysis? Did you have an opinion either way? Objection. What's your opinion on this? Basis, foundation. He asked him his opinion. He's not qualified as an expert for that. Overruled, of course. Please repeat the question. Did you draw a conclusion one way or another about whether the authors of this paper seemed to be applying a sound methodology or whether they were trying to reach a particular result? Based upon the conclusions they drew, I did not feel like they were objective in their conclusions that they came to, right? They were trying to make it fit. And that is exactly what we saw in the emails between Rodney Jaffe and even the tech researchers. They said that we've been trying very hard to make this thing connect, and they just haven't been able to do it. Brent Nias is here, says, wasn't being sarcastic on the topic. My GAI cert isn't as rare as the first agent, but this stuff is my profession. Any unbiased person in our field knew this was garbage evidence that said nothing. Oh, okay. So that was Brett. Brett sent a prior super chat, says, I'm at home listening to network inspection and detection talk. And I thought he was being sarcastic, but he wasn't. So he actually, sort of lives in this space, and he knows very clearly that it was all garbage, right? And they knew it was garbage. Everybody knew it was garbage, but it was October. They needed this badly. They knew that they were going down in the polls, and they ended up losing, right? This was a Hail Mary. This was a last-ditch effort. And thank you for the clarity on that, Brent, and for the support here for the show. But it is important, because if you don't understand sort of, I think, some of this base layer stuff as a juror, it's going to be hard to really understand the depth of the scam here. So thanks for the clarity on that, Brent. Any particular reasons that support this, saying that you don't believe them? Well, just the assumption you would have to make was so far reaching, it just didn't make any sense. Did you guys do anything with this after it was printed? Yeah, we sent it back over to Chicago. And were you comfortable that you reached your conclusions independent of any other bias? Yeah, very confident. No problem at all. He was my supervisor. We have drastically different views on various topics, but we came to the same conclusion when we were drafting this assessment. Talk about FBI Chicago. They passed on this. Why didn't the FBI in Chicago do anything with this? Well, there was no cyber equity. There was no hacking. There was no allegation of hacking. There was no hacking crime for us to investigate. That's why we didn't do anything with it. And FBI opened an investigation, though? Yeah, that's true. They did open it. Did you have any more involvement? Nope. Nothing else from me. Any names of other agents? He lists a few of them. Chicago looked at the data further, agreed with our assessment, did not concur with the idea that there was a secret communications channel. Talks about the different types of investigations at the FBI. Talks about the lowest level, middle level, high level. And then we see I want to see if we do actually get, here you go. Court's getting tired of this. Mr. DeFilippis, how much longer? Your Honor, less than 5 minutes. Okay, finish this up. Says, and in the case of Alpha Bank, what kind of investigation was open? It was a full investigation and they started digging into that. Would it have mattered to you about their political affiliations or motivations? And she's trying to sort of, I think, take the sting out of the cross-examination. We're going to see if he beats him up politically or not. But he's saying, I would have done this regardless of my political affiliation anyways. To what extent would it matter to you whether someone had a business interest or a relationship with the government? He says, look, for the same reasons, I would want to know. I want to know if it's going to have an impact. I'm going to look at it. It's going to give me some context about where it came from. So he's saying that Jim Baker would not tell him where these white papers came from, and that was problematic for him because it provided him with no context. If someone is providing the data on someone else's behalf, I want to know where it came from so I know their motivations. And then they stop. That's it. That's our lunch break. That's the last question. Thank you very much, Special Agent Hellman. Ladies and gentlemen, we're going to take our lunch break. Feel free to eat in the cafeteria. No research about this case. Hellman, you can step down. Don't discuss your testimony. Mr. Bosworth, you have something? Either now or after lunch when we get back. And that is it for the questions. Now, what is this here? Oh my goodness, they gave us an index on the transcripts, which we did not get yesterday. So we can see exactly every single line that these words are referenced. I did not get that yesterday. So I thought we had a lot more transcript to get through, but apparently we don't. So that's the end of it. Now, we did have one more witness that came in this afternoon. And so if we take a look at when this ended, let's see if we get a close time on this. Yeah, no recess close time, but all right, we did get one other witness that I will very unlikely get to today, but we'll pick it back up tomorrow a little bit. But I wanted to share with you this witness who is this guy, right? So Steve DeJong. Now, quick recap. Okay, we had our two witnesses today. We know everything we need to know about DNS records, and we have our official expert witness here on the show. Brent is here in the house. We're following this along. The jurors are up to speed on it. Don't need to talk too much more about it. Tomorrow, we're going to start up with Steve DeJong, who's a New Star employee, who was apparently working hand in hand with this guy over at New Star, Manos Antonokakis. Okay, now this guy is not going to be testifying. He's invoked his Fifth Amendment, but Steve DeJong is going to come in and testify. He actually has already testified. I don't know if he finished today or not, but I will get the transcript for that one later in the evening. And I will post that over on Locals, and I will add it to this mind map. So if you want to check out this mind map and take a sort of a preview on the transcripts, then those will be available later on in the day. But that's all that we've got on the Sussmann trial. I mean, we covered a lot. Opening arguments. I think things will pick up a little bit more. We'll be able to fly through some of the witnesses a little bit more quickly, depending on who we hear from. Tomorrow, we've got a ton of stuff scheduled. This was the witness list that they were talking about getting through. Deborah Fine, Laura Seago, she's also from Fusion GPS. Mark Elias, of course, major Democratic lawyer. Tom McMahon, Jim Baker, and Robbie Mook. Robbie Mook's probably not going to come out tomorrow. He'll be a part of the defense case in chief, but he was a big-time Hillary Clinton campaign advisor and a big name in the DNC. So the prosecution has decided not to call him, but the defense sounds like they will call him. So we'll be back tomorrow to do this whole thing again. And we'll see what those transcripts hold. I want to thank everybody for the super chats. Of course, these transcripts, as I read through them, they're about $1.20 a page. So every single one of those pages is $1.20. So I appreciate you being members. I appreciate your supporting us on Locals. I appreciate the super chats that came in today from Ronnie Cole, Vienticus Prime, 2 from Brent. Thank you very much for those. And if you are watching this after the fact, I enabled the super thanks button on the YouTube channel. So if you also want to contribute, you can certainly do that. Click that super thanks button. I very much appreciate it. And if you're not somebody who is able to do that, no worries at all. I would still appreciate a like, comment. I'd love it if you shared this video with some friends or family members and invited them on over here to come join us as we cover this story. Share the mind map link, share the transcripts. It's all meant to be shared. And I hope that it's useful and you're getting some enjoyment out of it. One final thing, I always forget to plug my law firm, but I'm super proud of the work that we're doing. We have a mission to help good people charged with crimes find safety, clarity, and hope, not only in their cases, but in their lives. We help with all types of criminal charges. Anytime somebody's in trouble with the law, we can help. We have an amazing team of people. And because of people like you referring us business, connecting with us here on this show, because I have an amazing team of people that I can also trust to do amazing work, we get to spend time together to talk about some of this stuff on the internet. And, I wrote about this in my book back in 2020, talking about the sort of the missing component of criminal justice being out there, the need for real accountability, transparency, for talking about, these very important issues that many people would just rather this get glossed over. These trials sort of just be swept under the rug. They don't want mind maps. They don't want public transcripts going out to everybody. And so if you do, enjoy the content and you appreciate the work, a share is very, very appreciated. But also if you're just thinking about, if you hear of somebody in the state of Arizona who is charged with a crime, right, that's our law firm. We're very good at what we do. And even though we can have a lot of fun and kind of get goofy here on the show, we're very serious when it comes to court, and we deliver amazing results, and we love to help people. So I'd appreciate your referrals. And your like before you got out of here. I saw a couple super chats come in that I wanted to get. And C. Reed is here. Sorry, says I can't dono more, but I can pledge 1 billion, same thing. Yeah. So like, especially Luna or Terra, right? If you got that cryptocurrency, I'll take a trillion of those. It should cost you like a dime, 10 cents or something. Another one came in from Jelly Bean with a super chat. Thank you for the support, Jelly Bean. And I don't like to come on here and shill for money, but the transcripts are this whole trial is going to cost several $1,000s. I think I'm getting the transcript. It's about $200 in the morning, $200 in the afternoon. So $400 a day times 10 days, right? It could add up pretty quickly. So I do appreciate it. It's a very, very nice one from Bill Meinhardt Jr. Thank you, Bill. And I don't see a question on that, but very generous. I appreciate that as well. And we're just going to keep plugging along. I hope you do enjoy it. And if there's any, other suggestions or any other things that you'd like to see, right? This is kind of a new thing that we're doing. We are going through the transcripts, and I know it's kind of boring to read through hundreds of these things or hundreds of pages of these things, but we're trying to mind map it. We're trying to make it interesting. But if you have any thoughts, I'd love them in the comments. I do read the comments. I don't always actually respond to them, but I do flip through them, and sometimes, oh, it's a great idea, and I will incorporate that. And if you do leave a super thanks after the show is over, I'll make sure I cover those on the following show because I do appreciate the support. Also want to plug locals. Okay, we have locals going on, and today on our locals community, I turn on the chat, which means I don't get comments on that same post. And so feel free to come join us over on locals as well. I'm trying to do a little bit more behind the scenes stuff. Like I did the other day, I did like a walk and talk video, which is very new for me. And I'm trying to become more, open and share more about some of the work that I'm working on. But it's a muscle that I am exercising, and I'm going to continue to do that. So I appreciate your support and your understanding, and I hope that you continue to join us. We're going to be back here to do it all again tomorrow. Harold Miller with another super chat that came in. Thank you, Harold Miller. Harold Miller. Bill Meinhardt Jr. Jelly Bean 60. C. Reed. Brent Nias with 2 of those. Vianticus Prime and Ronnie Cole. Thank you, everybody, for the super chat love. And that's going to be it for us for the day. I really appreciate you being here with us. I appreciate the support. Thank you for sharing this. Thank you for subscribing if you have not already subscribed. We're going to be back here to do it again tomorrow, probably right around the same time. I'm getting these at about 2:30, 2:45, almost 3 o'clock my time. So that's going to be about 6 p.m. Eastern time is when we'll cover all of this stuff. And our final super chat came in. 2 super chats came in. One from Harold Miller. Thank you, Harold Miller. And another one from Mark Powers. Thank you, Marks. And that one is very, very appreciated as well. And that's it, everybody. I hope that you enjoyed this. I hope you have an amazing evening. Sleep very well. We're going to be back here to do it all again tomorrow. Have a great night, my friends. See you on the next one. Bye-bye.